So friends, welcome to the 87th session of Legal Empowerment Through Interaction lecture series. Like always, the journey continues. Today also we are privileged with a wonderful speaker. Yesterday we had adoption, history, practice and procedure. Today we are on another facet of conspiracy. It is prosecutorial tendency in criminal cases involving conspiracy. We have Justice N.Anand Venkatesh to deal with the subject, and we are privileged by the presence of Justice Ramkumar sir also. So without any further formality, directly over to you.
Yeah. So good evening to all.
Good evening.
Thank you, Shyam, for inviting me. My pranams to Justice Ramkumar also. So yeah, it's a great sight to watch Justice Ramkumar attending this series. Every webinar, he does not miss even one of it. That is a great lesson which all of us, including myself, will have to learn from him, just to sustain and continue with that passion for the institution and his interest shown towards the profession is something fabulous. I have been noticing this for quite a long time. So this is one thing which I wanted to really inculcate from Justice Ramkumar here.
Thank you, sir. Thank you.
And this, insofar as today's topic is concerned, I would want to dedicate this more for the junior members of the bar who are present and listening to this. I thought that the senior members and the judges who are present and hearing can ably assist as and when a situation arises where I will be basically dividing my talk today into three segments. The first segment will be on a brief introduction about the provisions involved. The second segment will be on the law as it prevails today, insofar as the law of conspiracy is concerned. And the third is that I have prepared some illustrative cases based on some decided cases, just to demonstrate how the courts have been going ahead with dealing with cases involving conspiracy. And I have prepared some 5 or 6 illustrations. I'll see how time permits me. As much as possible, I'll try to deal with each and every one of it. And I would really be happy if there is participation at the time when we go into that illustration mode from the junior advocates, so that all of us will be benefited. All of us will be benefited. At the end of this lecture, what is important is that all of us must have learned 1 or 2 new things at the end of the session. And that's the entire attempt. Here, it's both learning and unlearning. We will learn certain new things. We will unlearn certain things which we have mistakenly, which we have understood it wrongly. So unlearning is also a very, very important aspect in the process of learning. And this is therefore, this is the whole attempt that I'll be making during this session. I always found that it will be more beneficial if the prosecution side also participates in sessions like this. See, the police do not know about common intention, about this common object, conspiracy, this, that, nothing. They don't actually know the purport of all these words. They don't appreciate all these things. So they must have the able assistance and guidance from the Directorate of Prosecution. That's the whole purpose of having a Directorate of Prosecution in every state. Or else what happens is that all these discussions and webinars becomes too one-sided, or it may become an intellectual gymnastics.
All the stakeholders.
Yes, if I may say, all the stakeholders must, if I may say. So in my opinion, we will be strength. If that does not happen, what will happen is that we will keep strengthening the defense side, who will always be able to find more and more loopholes into the whole thing. So I'm not trying to say that everybody should be benefited. See, weak prosecutions are not in the interest of the society. I'll have to say this to you, to all of you. See, I was sitting in a bench for almost 3 months, dealing exclusively with life sentence cases. Every time when a case comes up before us, we will know that it has happened. We will be sure that it has happened, but we will have no other go to acquit or allow the criminal appeal just because of the way in which the prosecution has gone ahead with the prosecution and the materials that were collected during the course of the investigation. So I would always find that sort of helplessness where we will not be able to do anything except to go ahead and allow the criminal appeal. So I always thought that if the prosecution does not know how to collect evidence involving conspiracy and establish that charge, then I think that these the sessions which we are conducting or the attempts that we are making are all purely academic exercises, and it is not going to really cater to the needs of the society. That is where I am trying to focus. It's very important that these programs will have to reach the persons concerned, because at the end of the day, society believes in the system. If the society is to believe in this system, we'll have to strengthen the way in which the prosecutions are happening. Failing which, it'll all be theoretical discussions that keep happening, and the sloppy way in which the prosecution continues is going to continue. That is not good for the society, and therefore I would always be glad if there is a participation on the side of prosecution also in webinars of this nature.
Sir, is your state academy imparting training to the prosecutors?
Yes, yeah, it's happening, but the problem is that I have always felt that it is important that we should increase the number of programs there, or else what happens is that prosecution merely collects papers. They act like some post office. They just collect papers from the police, and even without reading anything, they just go ahead and do it. I know that it is quite effective there in Kerala. I've always admired the way in which it happens in Kerala. But I always felt overall, whenever we do sessions like this, whenever we try to really focus on certain things, where we find that the prosecution is lacking, I always thought that it is better that they are also part of this whole thing. The whole of the criminal justice system is not only defense; it also involves the prosecution, and so it's very important. And the other important thing which I want to say before I go into the subject is that I find a tendency that we get too much bogged down by precedents. I think we are getting too much bogged down by citations. It has gone to such an extent where instead of having a shirt for the body, we are now searching for a body for a shirt. Meaning the body, I mean, is the facts of the case, and the shirt, I mean, is the case law or the precedent that involved in it. So the facts of the case are more important, and the precedents will have to cater to the facts of the case. And whereas due to the easy availability of the case laws across India, the tendency is that first keep the case law and then try to adjust your facts of the case into the case law. That is actually having a very, very huge impact. That's something which on a daily basis I am able to see even in court. So what happens is that in criminal law, particularly in criminal law, according to me, facts and the ingredients of the offense must be focused. And precedents generally take a backseat when it comes to criminal law, unless and otherwise it is necessary for the court to understand with regard to the ingredients involved in an offense and how courts have dealt with it. Or else what happens is that if we continuously start looking at citations, our ability of original thinking gets killed. And if we are going to write judgments purely based on these precedents, I think that it is more nothing but a borrowed intelligence, and there is no originality that is involved in it. So it's important that we also develop this ability of original thinking, develop this ability of reading the provisions as it is and trying to understand it. And as and when we want to, I'm not trying to, after all, we are all bound by the law of precedents, that's right. But then in order to really develop ourselves, in order to really open up the thinking process, it's always better to look at provisions and read it, and have the precedents only as assistants. And we should not have the precedents in our mind and start looking at everything. Then our focus gets very jaundiced, and our focus gets very, very limited to that extent, is what I feel. So, so the concerns, today's focus is this. For today's, I'm trying to focus more in to see why the prosecution is not, in many cases, adding section 120B as a charge, and why they feel it comfortable to have a 34 or 149 in its place. Why is it that they are not very comfortable in adding 120B as a charge? Is it because of some ignorance, or is it a hesitation on the part of the prosecution, which over a period of time finds that it becomes almost impossible to prove cases of conspiracy before courts? This is something which we have to have in our mind, and that's the reason why I had given the title for the topic today as the prosecutorial tendency. So with this small introduction, I want to get into the topic. See, the offense of criminal conspiracy came into the code only by virtue of this Criminal Amendment Act 1913. See, section 121 capital A was the only provision which directly dealt with the subject of conspiracy before that. It made conspiracy by itself an offense. Conspiracy by itself an offense when the conspiracy pertained to the offense that were committed under section 121, which is waging war against the government of India, etc. We had 107 in the code, 107, which included one facet of conspiracy in the second limb, 107.2. And the requirement under 107.2, as all of you will be knowing, is, this is more for the benefit of juniors, as all of you must be knowing, is that it required an overt act. It basically required an overt act. So what it required a conspiracy, and it also required an overt act or an illegal omission in order to make it punishable under the second limb of section 107. So at that point of time, what happened was that in the common law in England, conspiracy there by itself was an offense. It was defined, as you can see from Mulkey versus Queen. If you can put up the, yeah. So just, yeah. So this is where it got in. If you can look at the screen, yeah. So this was a definition. The definition under 120A of IPC was set out, was taken from only this judgment in Mulkey versus the Queen. It seems, look at the following: a conspiracy consists not merely in the intention of two or more, but in the agreement of two or more to do an unlawful act, or to do a lawful act by unlawful means. This is exactly the wordings that were available there of Justice Wiles. So this is where we took this concept of conspiracy, and this was sought to be brought into this country, and thereby conspiracy was made as an independent offense by virtue of this 1913 amendment that was brought in. The reach of section 10 of the Evidence Act and section 120 capital A of IPC was designed to be very wide. It was designed to be very wide. And in criminal law as a rule, as you all must be knowing, in criminal law as a rule, one person is not held liable for another person's action. This is fundamental in criminal law, and all of you know it. However, a criminal act may have been committed in furtherance of a common intention, or in prosecution of a common object, or it may have been abetted, or it may be in pursuance of a criminal conspiracy. So when all these things get in, the theory of vicarious liability, or I would call as the constructive liability, is brought in, and it is aimed at bringing these instigators, these conspirators, and those facilitating the offense into this net. So basically what you are attempting to do is you are attempting to bring in those persons who are also involved in it, but who are behind the screen. You are trying to bring them from the dark and also pull them into the offense that has been committed by those persons whom you actually see. So this is the whole concept of this, and the type of offenders whom I said involved in conspiracy are offenders who are not in the forefront. They are not in the forefront, and therefore the criminal liability is brought in by a legal fiction, by which the mens rea is imputed on the basis of the overt or the covert act of the offender. This is the whole concept of this constructive liability that is sought to be brought into the criminal law. See the section 120A, you can look at the screen, it's available. I would straight away go to section 120A of the code, Indian Penal Code. You can read it, and what can we deduce from it? We can deduce from it that the essence of the offense of criminal conspiracy is 1, 2 or more persons agreed to do or caused to be done what? An illegal act. An illegal act. So illegal, the way in which we understand illegal is the one which is found under section 43 of IPC, which defines illegal as everything which is an offense, everything which is an offense or which is prohibited by law, or which furnishes a ground for a civil action. This is how illegal is defined under the Indian Penal Code under section 43, which is an offense or which is prohibited by law, or which furnishes a ground for a civil action. This is how illegal is. And act is, as you all know, defined under section 32 and 33 of the Indian Penal Code. So 2 or more persons agreeing to do or caused to be done what? Caused to be done an illegal act. Illegal act as we understood by reading section 43 read with 32 and 33. Or legal act by illegal means. Legal act by illegal means. Then the next thing is section 43 talks about an offense. What is an offense must also be understood by us in order to really appreciate what gets into the ambit of this provision. Offense is again defined under section 40 of the Indian Penal Code. So section 40 basically it denotes a thing made punishable under this code or under any other special or local law. So that is very clear when we read section 40 of the Penal Code. So when 2 or more persons agree to do or cause to be done an illegal act or a legal act by illegal means, that has now been made per se punishable. So the big divergence that took place, big difference that took place was that even though this facet of conspiracy was available under 107.2 earlier, 107.2 required not a mere meeting of minds and a consensus at item. It must be followed with an act, something more than the consensus at item, and the language under 107.2 itself clearly stipulates that. But the very meeting of minds itself was made punishable by bringing in this definition of conspiracy under 120 capital A. And as you all know, 120 capital B is the provision which provides for the punishment for the offense of conspiracy. It has basically it has two facets to it. See, the offense of conspiracy is based on the principles of partnership and agency. Just as you find in a partnership, every partner is a principal and agent vis-a-vis every other partner. As you all know this concept under the Partnership Act. Same way in a criminal conspiracy, every conspirator is in a similar situation as against the other conspirators. Same principle has been brought in. So the act done by one is considered to be an act done by all. This is the simple way of understanding this offense of this definition of conspiracy under 120. Then when we get into section, I'll get into the proviso to section 120 after I deal with 10, and then I'll get into. If you get into section 10, the 10 of the Evidence Act, it becomes important to look at section 10 of the Evidence Act also. If you can slightly move up the section 10 of the Evidence Act deals with things that are said or done by the conspirator in reference to the common design, and it makes certain facts relevant in proof of that conspiracy. This is the whole concept of section 10. I'll again repeat. It deals with things said or done by a conspirator in reference to a common design, and it makes certain facts relevant while proving the charge of conspiracy. That's the scope of section 10. So if you look at section 10, I have titled it as loosening the strings. There is a reason why I put that word loosening the strings, and as I progress, I will tell you why it is required, particularly in a case of a conspiracy. So what happens in 10? If we read section 10, what is that we get out of it? I don't want to really repeat it. It is available in the screen. So I would want to deduce what comes out of this section 10. See, section 10 of the Evidence Act, see, it provides for the following. One is, there is a reasonable ground to believe. There is a reasonable ground to believe. Underline the word reasonable ground. It is not evidence or it is not strict proof. What is required is a reasonable grounds to believe. What? That two or more persons have conspired together to commit an offense or an actionable wrong. Two or more persons have conspired together to commit an offense as we understood under section 40 of the IPC, or an actionable wrong. An actionable wrong is a civil wrong or a tort, as we understand. So while doing that, anything said, done or written by any one of such person, there are more than one person, anything said, done or written by any one of such persons on what? In reference to their common intention. In reference to their, please underline this word, in reference to their common intention. In furtherance is the word which we find in section 34. Here it is in reference to their common intention, reference. So in reference to their common intention, then further what does it say? In reference to their common intention, from when? After the time when such intention was first entertained. So it starts. What is the starting point? The starting point is that the common intention starts after the time when such an intention was first entertained. So it would have been entertained by a person, first person. So from the time he entertained it, and from then on, whatever happens, so the starting point is the time when the intention was first entertained by any one of the conspirators. And it becomes relevant. It becomes relevant. Against whom? It becomes relevant. Against whom? It becomes relevant under three circumstances. One is, as against each of the person believed to be so conspiring. So it is binding or it is relevant as against each of the person who is believed to be so conspiring. A. B is for the purpose of proving the very existence of the conspiracy. For the purpose of proving the very existence of the conspiracy. And C is for the purpose of showing that any such person was a party to it. So any such person is a party to it. So if we read section 10 and try to reduce it into small portions, this is what we find under section 10. So, and I will again repeat for the benefit of the juniors, there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, and anything that is said, done, or written by any one of such persons in reference to their common intention, from when? After the time when such intention was first entertained by any one of them, it becomes relevant for three purposes. It becomes relevant, A, as against each of the person believed to be so conspiring. B, for the purpose of proving the existence of the conspiracy. And C, for the purpose of showing that any such person was a party to the conspiracy. This is the purport of, as you can see, the scope of section 10. At this point of time, it's important to notice certain catch words, I would say, catch words under section 10. The catch words under section 10 are reasonable ground to believe, intention entertained by one of them. This is another catchword there. Intention entertained by one of them. Why should you know this catchword? You should know this catchword because that is the starting point. Then others join in, like in a train. They join in from the beginning, or they join in the middle. They remain till the end, or they get out in the middle. So from the time it was entertained by a person till the act is done, whoever gets in or gets out, or whoever gets in and stays till the final act is performed, all of them get into this bracket. And so till the act is performed. So these are the catchwords, I would say, or the important words or terms that are used under section 10. Now, while trying to understand this section 10, I said that I'll go back to 120 capital A and look at the proviso. I thought after looking at 10, if we go back to 120A provisos, we will understand it even more better. If you can take it down to the proviso, sir. See, the proviso to section 120 capital A makes it very clear that, yes, it makes it very clear that a mere agreement to commit an offense is punishable. A mere agreement to commit an offense by itself is punishable. It itself is considered to be an overt act. Whereas a mere agreement to commit a tort or a civil wrong is not an offense, is not punishable unless an overt act is committed in pursuance of that agreement by any of the conspirators. So we are able to get two types of persons who are being dealt with under the proviso to section 120A. 120A makes the very agreement to punishable, agreement to commit an offense punishable, and whereas when it comes to an agreement to commit a tort, agreement to commit a civil wrong, then unless an overt act is committed in pursuance of that agreement, it is not punishable, is clear from the proviso itself. The second portion of it, I always had my own opinion on that. Let me see how there are two portions, as you can see. One portion is the agreement to commit an offense. I am fine with it. The second portion is the agreement to commit a tort which requires overact. I always was wondering as to why they have attempted to really bring in under a criminal offense. And I had the benefit of also hearing Justice P.N. Prakash, who had given some illustrations on that. So therefore, he was giving an illustration on the advocates going on a strike. He gave an illustration saying that the tenants join together and they decide not to pay rent. I very clearly remember what he said on that. So therefore, I don't want to really go ahead and deal with it. But please see, this as I said, we have picked it from the common law. But see, there is a big change that has happened actually in England, and we have not followed it up. Please now, Mr. Sharath, can you go into that illegal act portion, last portion, the illegal acts, the second portion of it. Last one, the illegal acts portion. Yes. See, so this first I will deal with the second portion of the proviso, and there are 2-3 things which I want to touch upon. From there on, we will go into the road. See, the common law definition of a conspiracy, which finds the statutory recognition in section 120 capital A, penalizes an agreement to commit an offense as under 40, as well as an unlawful act, which I have already said is dealt with under 43 of IPC. See, the use of the expression unlawful means it was felt that there was a tendency to create new offenses within its net. This was felt very long back, and the judgment of the House of Lords in R versus Bhagavan, as you can see. R versus Bhagavan, you please see what is stated there. See, the facts of the case was that this Dharam Singh Bhagavan had entered into a conspiracy with a master of a ship to illegally bring him to England. See, even though his entry into England was not an offense per se under the Immigration Act of 1967, the question before the court was whether Bhagavan could be convicted for the common law offense of conspiracy, since his entry was itself unlawful, though it is not a statutory offense under the Immigration Act of 1967. Please look at the wordings of Justice Lord Diplock. I want to straight away read it. See what he has observed. My lords, the disposition of the instant appeal does not, in my opinion, call for a general survey of the current role of criminal conspiracy in the common law. The least systematic, the most irrational branch of English penal law, it still rests upon a legal fiction that the offense lies not in the overacts themselves, which are injurious to the common weal, but in an inferred anterior agreement to commit them. Your lordship should not be zealous to use this legal fiction to create new offenses of acts not previously recognized as criminal at common law, which Parliament itself, in intervening to change the common law, has not expressly penalized. This was a strongly worded order that was passed by Diplock. After this, what happened was that they brought in an amendment in England in 1976, pursuant to the Lord Diplock's recommendation. What happened was they have abolished the common law offense of conspiracy insofar as that unlawful act is concerned. Now conspiracy is confined only to the offense portion of it, only to the first portion of it. Committing an offense alone is now confined. They have removed the second portion in England after this Diplock's observations made in that judgment. So Now it is defined as you can see. This is the new definition that is now available in England. If a person agrees with any other person or persons that a course of conduct shall be pursued with, if the agreement is carried out in accordance with their intentions, either will necessarily amount to or involve the commission of any offence or offences by any one or more of the parties to the agreement, or would be so but for the existence of fact which render the commission of the offence or any offences impossible, he is guilty of conspiracy to commit the offence or offences in question. So, in short, what they have done is that they have knocked off the second portion of 120A altogether, as we have it here. But somehow we continue to have it in our book, and it is not as if it was not noticed by us. In fact, this was noticed by us even before UK had amended it. You can see that it was noticed by the Law Commission as early as in see the 42nd report. Can you just take it up? The 42nd report of the Law Commission, in fact, had arrived at the same conclusion in 1971. This amendment in England came much later, and we have actually identified it. Where the report was given by the Law Commission, and it gave its own reasons as to why it need not be present in the present form and in 120A, which complicates it. So, so this is the reason that was given. I don't want to really repeat it. It is available on the screen. It basically said that you should not be continuing with it, and they said that it is originating from the criminal equity administered in the Star Chamber. The Star Chamber. That's what they said. So can you take it up? So this was the recommendation. 5.3. This is the recommendation. Revised definition of a criminal conspiracy. They say we are strongly of the view that there is neither theoretical jurisdiction nor practical need for punishing agreements to commit a petty offence or a non-criminal illegal acts. In practice, few private prosecutions of such petty conspiracies are sanctioned by the state government or its offences under section 196 capital A of the Criminal Procedure Code. We therefore recommend that section 120A, which defines criminal conspiracy, should be revised as follows. My dear friends, this was a recommendation in 1971. We are in 2020. Please look at the recommendation that was made by the Law Commission. It said, it made it very simple definition. What is that? When two or more persons agree to commit an offence, punishable with death, imprisonment for life, or imprisonment of either description for a term of 2 years or upwards, or to cause such an offence to be committed, the agreement is designated as a criminal conspiracy. See how simple it is. See how simple they have made that definition. But we never like simplicity. For us, law must always be complicated. Law must always confuse people. Then we will be happily retaining it. And this is that simple amendment that was recommended in 1971. See how simple that definition. There is no complication in the definition at all. They focused on two things. They basically took out of the net of section 120A petty offences. Look at that. It covered only those offences from 2 years and upwards. Below that, everything has been knocked off. They took it away. They said that 2 years and upwards. Try to bring in this criminal conspiracy into serious cases and don't get into petty offences of criminal conspiracy. One, because it never happens. Or they also knocked off the agreements to commit this unlawful act, this civil actions, these torts, etc. So this is what was recommended. I thought that it will benefit the junior members of the bar that there was such a recommendation that was made in order to simplify, but this remains in cold storage. This continues to remain in cold storage. Then there was another recommendation made by the Law Commission. This recommendation was made by the explanations are the same. So I do not want to read the explanations. Can you go to the next Law Commission report? Yeah. So there was one more recommendation that was made by the Law Commission, where they said that you are duplicating it. If you want to retain where you have already made the offense of criminal conspiracy, meeting of minds per se as an overt act and punishable, why are you retaining 107?
107.
107. Why are you retaining it? Is the next question. See, the underlined portion, it makes a lot of sense in what the Law Commission said. See what they say. After the enactment in 1913 of 120A and 120B, making conspiracy itself an offense punishable in the same manner as an abatement of an offense by conspiracy has lost its raison d'etre and could well have been taken out of Chapter 5 altogether. In fact, the coexistence of the two ideas in the Indian Penal Code only leads to some confusion in applying them. Anglo-American legal systems which admit the idea of criminal conspiracy as such and make it punishable do not contemplate abatement of an offense by mere agreement to commit it. We propose that the second paragraph of section 107 and all subsequent references in chapter 5 to abatement by conspiracy should be omitted. This was a very important recommendation that was made by the Law Commission, and the Law Commission said that you are unnecessarily confusing by retaining 107, the second limb of section 107, when you have already brought in section 120A and 120B. So therefore, they said that why is that you are retaining it, and it's better that you remove it off. But then, as I told you, we always want law to be confusing. We always do not want to have a simple, straightforward law, because if it is like that, then we have a sort of anitama for all such simple things, basically. So,
sir, who was manning the heading the Law Commission?
During that point of time, I am not really aware.
Okay.
I'll get back on that. So therefore, this was the very important recommendation that was made at that point of time, but this did not go through. So I wanted to bring this to your notice only to impress upon you that the unwanted portions of section 120A were recommended to be removed and confine it only to the offense part of it, and even in the offense part of it, to make it applicable only to those serious offenses where I have recognized it as punishable with 2 years and more. This was one recommendation. Other is avoid duplication by unnecessarily retaining 107(2) and the other related provisions which touches upon conspiracy. You are causing confusion. So once 120A and 120B have come into the book, there is no requirement to have that. That is also remaining in cold storage. So this is something which has already been thought through by the Law Commission and recommended long back, but it has not come into force, is what I am saying. So the next thing into which I want to move is the I had the advantage of listening to Justice P.N. Prakash, and I also had the advantage of listening to Justice Nagamuthu some time ago. So therefore, Justice P.N. Prakash had gone in detail with regard to the scope of this 120A and section 10, and Justice Nagamuthu had also gone in detail with regard to common intention, etc. So therefore, I will not want to touch upon all those things. I wanted to basically introduce the subject this way so that you will come into grips and you will basically know the purport of these provisions. So that is my only aim here. Then the next thing into which I want to venture into is the illustration part. Can you go into the illustration to section 10? Illustration to section 10. Mr. Sharad, can you go into the illustration part of section? Yes. See, to understand section 10, if you read the illustration, I think this is one of the best illustrations for section 10. Look at the illustration. The facts that B procured arms in Europe for the purpose of the conspiracy. C collected money in Calcutta for a like object. D persuaded the persons to join the conspiracy in Bombay. E published writings advocating the object in view at Agra. And F transmitted from Delhi to G at Kabul the money which C had collected at Calcutta. And the contents of a letter written by H giving an account of the conspiracy. Every fact is relevant. Each relevant, both to prove what? To prove the existence of the conspiracy and to prove A's complicity in it. Although he may have been, this is very important, although he may have been ignorant of all of them, and although the persons by whom they were done were strangers to him. Those persons may not even know that A was the one who is involved. They may not even be knowing for whom they are doing all these things to them. And although they may have taken place before he joined the conspiracy or after he left. Please understand these two words, very important. And although they may have taken place before he joined the conspiracy or after he left it. So therefore I said that the starting point of the conspiracy, as I would want to again repeat, is the time when the intention was first entertained. And the ending point is the actual overt that was committed. So between these two stations, I would call these as these two stations, the persons who get in and get out in each station till the exact overt is made, it is irrelevant that the person who gets in either in the beginning or in the middle either continues to stay till the end or gets down even in the middle itself. Whatever happens, each one of them becomes liable for the ultimate act that was committed. Each one of them becomes liable for it. So that is the actual danger in section 10. So this is how it acts. So this illustration is an illustration which is broad enough to bring in all the facets of section 10. This is such a beautiful illustration of James Stephen which he has given in this. So I thought that this illustration will throw a lot of light on the purport of section 10. Section 10 has already been discussed by Justice P.N. Prakash, so I do not want to really get into it more. So the next thing I want to do is to basically see. I also heard one more thing which was coming out of many discussions that had taken place in this in various sessions. I found why is it that in offences where it involves 34 common intention or an offence which involves a common object under 149, even though it is also a case of meeting of minds, there is a tendency that the prosecution does not really frame a charge or file a final report with a charge for an offence of conspiracy under 120B. There is a lot of discussion that went on, and I'm sure all of you are aware of it. I want to basically read or look at the interplay between, before you understand what was actually said and what was actually discussed. I want you to first understand the interplay between section 10, section 120 capital A and section 34. This interplay you have to understand, then only you will understand as to why that question was posed in this forum. See, for triggering the rule of evidence, see, section 10 is a rule of evidence like section 34. For triggering this rule of evidence in section 10, as I told you, a mere reasonable ground to believe is sufficient. Mere reasonable ground to believe is sufficient. Though For the ultimate offense, which is sought to be proved, the proof is beyond reasonable doubts. You have to understand that difference. So it's again, I'll repeat, for triggering the rule of evidence in section 10, mere reasonable ground to believe is sufficient, though proof beyond reasonable doubt will be necessary for proving an offense through what? Through the facts made relevant by section 10. Through the facts that are made relevant under section 10. You will have to understand it very clearly. Only then you will be able to understand that interplay. That interplay is this. Interplay is this. Ultimately, when the offense is sought to be proved, the real test of criminal law, where beyond reasonable doubt, comes into play. But when it comes to this relevant fact under section 10, then reasonable ground to believe is the one which is provided under the Act. So, under section 120 capital A of IPC, the agreement between the conspirators is per se an overt act. It is per se an overt act. There is nothing more required. It is per se an overt act to constitute the offense of criminal conspiracy or to commit a crime, and nothing more is needed. Nothing more is needed unless it is an agreement to commit a tort, that actionable claim which I said. So this is the marked difference it has from 107 to 10. While section 10, this is important, I want you to carefully listen to what I am saying, and if I am wrong, I am ready to correct myself also. Section 10 deals with the proof of the second stage of the resultant offense. Section 120A deals with the first stage of criminal conspiracy, according to me. I'll again repeat. Section 10 deals with the proof of the second stage of the resultant offense. Section 120A deals with the first stage of criminal conspiracy. And what is important is the liability for the primary offense of criminal conspiracy that should not be combined into one. It's very important to understand. It should not be combined into one with the liability of the resultant offense. So there are two things here. One is the very agreement to commit an offense, and the second is the ultimate offense that is committed. These are two different things altogether, and these two need not be combined in every case. In the first case, the very agreement to commit an offense by itself has been made as an offense. And what is important is that the primary offense of criminal conspiracy should not always be combined into one with the liability for the resultant offense. So, whoever has participated at the time of conspiracy and have got down in one of those stations before the train reached the ultimate junction, they will be liable only for the portion of conspiracy. And the person who travels till the end and commits the overtake will be liable for two punishments. One is the criminal conspiracy, and the next is the overtake by itself. It's very important to understand this. So, in the absence of even that minimal, so therefore what happens is that the conspirators are punishable in two ways here. The reason why Justice Nagamuthu was insisting as to why you are not having a charge under 120B in all cases where you find a common intention, he was posing this question only for this purpose, because there are two offenses that will be ultimately committed. One offense is the mere meeting of minds to enter into a conspiracy, and the other is the resultant offense. You can call it as a resultant offense. So, a persons who are involved in it, it is possible that the person who was involved in the conspiracy may also would have traveled in the train till the final destination and committed the overtake also, in which case he becomes punishable for both the criminal conspiracy as well as the resultant offense. Whereas persons who had got in at the time of conspiracy and who had not traveled till the end when the overt act was committed, they will be liable for punishment under section 120B. And they may not be, or they will not be punished for the final offense, even though the punishment is dependent upon that final overt act. It's important to understand this interplay between 10 and 120A. So therefore, what did he say? He said that if you don't do it, what happens is, if you don't have a charge for 120A, what happens? 120B, what happens is that you are ultimately only punishing persons who committed that resultant offense, who committed that ultimate offense, and there is a possibility that the persons who actually entered into a conspiracy, they are going scot-free. They are going scot-free. As you all know, 34 is again a rule of evidence. 34 is again a rule of evidence. So 34 has one scope, 149 has another scope, but all these things do not make it per se an offense. That's what he was trying to say. So insofar as 34 is concerned, I wanted to say the interplay. So two interplays I have said. One is section 10, another is 120A. And the other thing of 34 is, in 34, the mere presence of a person at the time of commission of an offense is not enough. Is not enough. What is required? Unless there is a common intention and participation. It's a dual requirement under 34. There must be a common intention as between the parties and the participation of both or more than two, and both present. Only then 34 will apply. So even though it will look as if 34 and 120A's requirement is the same, but these are different stages. 34, mere intention without anything more is not an offense, because 34 is a rule of evidence. 120A, there is a meeting of mind of two or more persons to commit an offense, which per se makes it an offense punishable under 120B without even expecting an overt act. And apart from that, the persons who travel till the end and commit the overt act, one more punishment is added. So there are two punishments for persons who are involved in the conspiracy and the final offense. So I have made myself clear on this before I proceed. I hope that I made myself clear on this. So this is the interplay you have to understand between 120A and section 10. This is very, very, very important. Okay. So and I said that in 34, mere presence is not enough unless there is a common intention and participation. So something more is required for the purpose of bringing in section 34 of IPC. And 34 of IPC is always read with the ultimate overt act for which the punishment is given. 34 is not an offense. It's only a rule of evidence. Now, let us go into how, let us go and see how courts have interpreted this. How courts have, see, there are two scenarios now. If you read section 10, it talks about, it makes it a relevant fact from when? It makes it a relevant fact from the time when the intention was first entertained up to the overt act. It makes it relevant. All those things that are said, done or written by any one of such person during this period will be put against every conspirator who is involved in this particular conspiracy. Now, this we understand. Now the question is, should this be confined only to those things that are said, done or written before the overt act was committed, or it can also include that which was said subsequently after the arrest, after the overt act was done, but which confines itself to this period? I'll again repeat myself to understand it clearly. Section 10 makes it relevant only for, the fact becomes relevant as against the others only when the thing said, done or written in reference to the common intention after the time when such intention was first entertained up to the time when it was actually committed. Whatever was done, said, each of the conspirator will be liable. Then the question is whether after the act was done, after the arrest takes place, thereafter a statement is made or a confession is made, which pertains itself to those acts, to those things done or to those things written, can also be brought within the bracket of section 10 is a very important consideration which you have to understand. So therefore, I would want to get into the case laws on that. I have made it very easy in my notes so that I don't get into the, Mr. Sharad, can you go into that? I would want you to first look into this Mirza Akbar case. This is AR 1940 Privy Council, page 176. See, the facts of the case are very simple. First, before going into the findings, the facts of the case in this is that one Meher Teja, who was the wife of Ali Asgar, she developed an illicit relationship with this Mirza Akbar, and both of them decided to do away with Ali Asgar. So they engaged a professional killer. His name is Omar Sher. They engaged him. There were certain letters that were exchanged between Meher Teja and Mirza Akbar, even before the murder was committed, which contained the crucial evidence of that criminal intention to get rid of this Ali Asgar, the husband of that lady. And Meher Teja's, and there were also materials which were collected after the incident took place and which Meher Teja, as by way of a statement, had made after his arrest. And the evidence that was given, or the statements, or the materials that were collected also pertained to the period when this plan was going on between the wife of the deceased and this Mirza Akbar. So there were two sets of materials that were available. One set of material is the letters that were exchanged between the parties before the act was committed. The second set of material is the statements that were made by Meher Teja after her arrest. So that question was decided by Mirza Akbar. Now you look into the screen. Mirza Akbar, see what they say. The words common intention signify a common intention existing at the time when the thing was said, done or written by one of them. Things said, done or written while the conspiracy was on foot are relevant as evidence of the common intention. Once reasonable ground has been shown to believe in its existence. Till then we all understand. Section 10, we understand that scope. But it would be very different matter to hold that any narrative or statement or confession made to a third party after the common intention or conspiracy was no longer operating and had ceased to exist is admissible against the other party. There is then no common intention of the conspirators to which the statement can have reference. In their lordship's judgment, section 10 embodies this principle. So they made it very clear in Mirza Akbar that the moment the act has been completed, thereafter whatever has been said, whatever statement has been made, whatever narrative has been made, whatever confession has been made, cannot be brought within the ambit of section 10. They have virtually curtailed section 10 to this extent. Section 10 is now confined only to those things that are said, done or written when the conspiracy was on foot, meaning when the conspiracy was on sustenance and it was at the stage when the overt act had not happened. So all those things were confined tightly into that. under section 10. This is what Mirza Akbar said. If you look at this, then this was affirmed after independence. This was affirmed by the Hon'ble Supreme Court in Sardul Singh, which we call it as Kavashir 1 case. Kavashir 1 case, which is AR 1957 Supreme Court, page 747. This was affirmed by the Supreme Court. It was followed by the Supreme Court. Then came a very, very interesting judgment in Bhagavan Swarup Lal case. Bhagavan Swarup Lal case is AR 1965 Supreme Court, page 682. This judgment was authored by Justice Subbarao. He took a very different view of that. Please see what he says. There are 5 things which he said. You can see the screen, it is available. 1, there shall be a prima facie evidence affording a reasonable ground for a court to believe that 2 or more persons are members of a conspiracy. So, prima facie evidence affording a reasonable ground for a court to believe that 2 or more persons are members of a conspiracy. 2, if the said condition is fulfilled, then anything said, done or written by any one of them in reference to their common intention will be evidence against the other. We understand that. 2. 3, anything said, done or written by him should have been said, done or written by him after the intention was formed by any one of them. This is again a requirement under section 10, we understand. 4, it would also be relevant for the said purpose against another who entered the conspiracy, whether it was said, done or written before he entered the conspiracy or after he left it. And it can only be used against a co-conspirator and not in his favor. These are the 5 principles that came out of that judgment. See, that 4th limb is very important. 4th point or the 4th limb I would call is very important in that judgment. This 4th limb was wider than the test that was applied in Mirza Akbar. You would have seen that in Mirza Akbar, they confined it to that. In this judgment, what they did was that when it goes back to, it relates back to the incidents that took place between that intention and that incident, then even then it becomes a relevant fact is what was said. So the 4th limb was wider than the test that was made by Privy Council in Mirza Akbar, and this was approved by an earlier 3 bench in Sardul Singh Kawashi. See, the ambiguity was compounded after this judgment in Kehar Singh vs. State. Kehar Singh vs. State was the judgment reported in 1988 3 SEC page 609. Basically, this judgment had 3 judges in it. See what has happened. Justice Oja, he relies upon the test that was formulated by Subbarao in Sardul Singh. Jagannath Shetty, he applies the test that was formulated in Kavashi, 1957, which I said, which in turn followed Mirza Akbar. So another judge followed, Jagannath Shetty followed the test that was formulated in Kavashi in 1957 and Mirza Akbar. The 3rd judge, B.C. Ray, he did not express any opinion on this point. But he agreed with both Oza and Shetty. So this is again a 3-member bench. Please, that is the reason why I wanted to point it out. The earlier judgment which I quoted in of Subbarao is also a 3-member bench. That is also a 3-member bench which was authored by Subbarao. And when it came to Kehar Singh, which is again a 3-member bench, the 3-member bench had 3 different opinions. One opinion was in line with the Sardul Singh judgment of Subbarao. One judgment was following the Mirza Akbar doctrine, which was followed in Kavashi. And the 3rd judge basically did not express any opinion, but he agreed with both the judges. So I do not know how we have to understand this particular judgment. Then comes the next important judgment in State of Gujarat versus Muhammad Atiq. State of Gujarat versus Muhammad Atiq. This is 1994 4 SCC, page 351. This is a two-member bench. This is a case, I think, arising out of Tada. See, again, paragraph number 14 becomes important. Three-member bench of this court in Bhagavan Swarup Lal Bhishan in so and so said that the expression in reference to their common intention is wider than the words in furtherance of their common intention. I asked you to underline this word. This 34 and this reference said that the expression is wider than the words in furtherance of their common intention, and is very comprehensive, and it appears to have been designedly used to give it a wider scope than the words in furtherance of in the English law. Even if it is wider, would its width go beyond the period of conspiracy? That's the question. It is well nigh settled that section 10 of the Evidence Act is founded on the principle of law of agency by rendering the statement or the act of one conspirator binding on the other if it was said during the subsistence of the common intention as between the conspirators. If so, once the common intention ceased to exist, any statement made by a former conspirator thereafter cannot be regarded as the one made in reference to their common intention. In other words, this is important. A post-arrest statement made to a police officer, whether it is a confession or otherwise, touching his involvement in the conspiracy, would not fall within the ambit of section 10 of Evidence Act. This was made very clear in Muhammad Atiq. Then comes the judgment in State versus Muhammad Khalid. State versus Muhammad Khalid. That is a judgment reported in 2002, 7 SCC, page 334. Page 334. This judgment also virtually, if you can push it up here. This judgment also refers to Bhagavan Swarup case, 65 Supreme Court at paragraph number 38. Then please come down. Yes. Then please go up, sir. This is important. This paragraph is important. However, see, look at paragraph 40. Now 38, it makes it clear that it basically follows the earlier judgment, Atiq's judgment. Same proposition was made. Now please see 40. In a given case, however, this is important. I think that this will be taken note of in future cases. In a given case, however, if the object of conspiracy has not been achieved and there is still agreement to do the illegal act, the offense of a criminal conspiracy continues and section 10 of the Evidence Act applies. In other words, it cannot be said to be a rule of universal application. The evidence in each case has to be tested, and the conclusions arrived at. In the present case, the prosecution has not led any evidence to show that any particular accused continued to be a member of the conspiracy after his arrest. So this is one explanation which came out of this judgment. So basically, even in this judgment, they made it very clear that post-arrest statements that are made by the accused persons cannot relate back to the things that were said, done, written during the period of conspiracy, and it virtually followed that earlier. This actually could have been resolved in State versus Navjot Sandhu. The Supreme Court had a real opportunity to deal with this issue. As you all know, this is this famous Parliament attack case. That is the State versus Navjot Sandhu case, 2005, 11 SCC, page 600. Can you just take it up? See what the Supreme Court says. You yourself can read it. Can you take it up, sir? Yes. see, this is where the two-judge bench did not choose to depart from the test formulated by the Privy Council. See, Venkatrami Reddy J observed, no doubt, the judgment in the second Kaveshar case, that is the Bhagavan Swarup Lal versus so-and-so, was of 3 learned judges. But the fourth proposition laid down therein is not so categorical as to convey the idea that even the confessional statement recorded after the arrest could be used against the co-conspirators. However much we are convinced of the arguments advanced by the learned counsel for the state, we are unable to give effect to the law laid down in these 2 cases, which runs counter to the larger bench decisions noticed supra, especially when the previous decisions bearing on the point were not discussed. This is what that judgment said. And basically, there is one beautiful judgment of Justice K.T. Thomas also in Damu case, State of Maharashtra versus Damu. That was a judgment reported in 2000, volume 6 SCC, page 269. I found it to be a very, very workable judgment. That was one judgment which could have been developed, but unfortunately it got overruled in this. So basically 2 judgments got overruled in this Navjot Sandhu. One was the judgment of Bhagavan Das. That is, I think, by Y.V. Chandrachud. That is 1974, 4 SCC 611. And the judgment of Justice K.T. Thomas in State of Maharashtra versus Damu. That is in 2000, volume 6 SCC, page 269. That was another important judgment which got basically overruled by this. So, as on today, we are clinging to the judgment of the Privy Council. So, we think that the judgment given by the Privy Council is the correct judgment, and therefore we have to continue to suffer with it, basically. So, there was a big chance. And I personally, I feel as a student of law that we missed that opportunity to really do something in this particular case, more particularly because of the pronouncement of Subbarao in that 65 Supreme Court judgment, which was again a 3-member bench. So there was a big opportunity for us. So this is where the law stands today. That's what I wanted to say. This is where the law stands today, and I am very hopeful that there will be a march of law in future, because if you are going to confine or read section 10 in this way, it will almost become impossible to prove or make facts relevant under section 10, because and that's why you will find the imagination of the prosecution where somebody behind the bush will be overhearing what 2 people are saying, or in a big shop, at the center of the shop, somebody will be sitting and he will be virtually in the top of his voice talking about a big conspiracy where he wants to attack the whole of this nation, and somebody will overhear that in that shop. So these types of imagination starts cropping up only because of this problem. So since it is now confined only to that period, and it cannot relate back after the arrest, post-arrest, this issue continues to be like this. And when it comes to section 10, I always felt that it is more like reverse engineering. I told you that when I was talking about the interface of section 10 and section 120A, section 10 basically is a reverse engineering process. It's a reverse engineering process. When does it actually come into play? It actually comes into play after the incident is complete. After the incident is complete. So what happens? What is present, what is now available is the actual incident, actual overtake that took place. And from there on, you go back and see where the conspiracy started. It's more a reverse engineering theory which happens in section 10. That's what is happening in section 10. So I liked one judgment of Justice P.N. Prakash on this, where he had said how the courts can deal with the evidence in cases of this nature. This was a judgment in Shali Priyadarshani versus State. Shali Priyadarshani versus State. You will find it in the screen also, where he says that in case of conspiracy, can you take it up?
Not reported.
It is, I think it is reported, sir. I'll try to, it is reported, I think.
Probably it would have been reported in Madras law.
Law Weekly, law journals. Yes, that's right. Can you take it up?
Criminal RC 11676.
1176, sir. 1176 of 2018, dated 17/9/2019. Can you take up the screen, sir? The slide. Basically, this is what he said after taking into consideration a lot of aspects. See, what it says is this judgment. Whereas in a case of conspiracy, every piece of evidence the prosecution proposes to adduce cannot be tested on the anvil of Section 10. During the trial court cannot be compelled to take a decision to admit it or reject it. In a case of conspiracy, this is important. In a case of conspiracy, the prosecution should be given a free hand to adduce relevant and admissible evidence, and while appreciating the evidence in toto, the court should see whether there is a reasonable ground to believe that two or more persons have conspired. The expression employed in Section 10 is not evidence to believe, but a reasonable ground to believe. When there is evidence to believe, then there is no necessity for Section 10. This is what he said. So basically, if you want to understand it better, you will remind yourself of Kashmira Singh judgment. What did the Supreme Court say in that? See, Section 30 talks about the confession of a co-accused. So there are two provisions under the Evidence Act. One is Section 133, other is Section 114B. If you read 133 and 114B, it will look as if both are contradicting each other. 133 will say that you can take it. 114B will say something else. Now, that came up before the Supreme Court. Supreme Court was saying that there is no contradiction at all, and this is how you have to do. What is that has to be done? What has to be done is that first, the confession of the co-accused, keep it aside. Don't look at it for the present. What you do is you marshal the evidence that is already available, and you look at all those things. Then you come to a conclusion first that the prosecution has established or proved all those facts. And then now you take into consideration the confession of the co-accused, and you see whether it is in line with that, what has already been established by the prosecution, and that will be an adding link to the case, and that is how you will have to use the evidence of the confession of a co-accused, is what the Supreme Court said in Kashmira Singh. Same thing, I think, was employed by Justice Prakash also. He says, don't test each and everything under Section 10 in the beginning. You allow the prosecution to adduce the evidence with all relevant facts which are admissible. You collect everything. After you collect everything, you deduce, you infer whether, by looking at the materials, that whether there is a design that has come up before the court which has been established by the prosecution. The test is what? Reasonable ground to believe. That is the test under Section 10. Then you employ Section 10, and thereafter you decide with regard to conspiracy. This is a more practical way of doing it. That's why I said that it is more like a reverse engineering. It's a reverse engineering process where you start from the overtake and actually you go back and see where the conspiracy started. That is the process. In order to do this process, you must allow the prosecution to adduce evidence, and you will have to let in or admit all relevant facts. And then with the facts that have been placed before the court, now you look at whether there is, when you read the entire material before you are able to find that there is a reasonable ground to believe that there is a conspiracy that is involved in a particular case. So this is more akin to what the Supreme Court said in Kashmir Singh. So when you are at the stage of letting in relevant and admissible evidence, don't test each and every one of them under 10. And what we must also understand is this: Section 10 is only one source. Is only one source of Evidence Act which makes a particular way of collecting a relevant fact or admitting a relevant fact in the cases of conspiracy. This is not the only one. There are various other provisions under the Evidence Act, under Section 8, under Section 6. There are when all these things come before the court, and the court, on looking at the entire evidence, is able to find that there is a clear case of conspiracy that has been established, then it is possible for the court to go ahead and punish the person for the charge under conspiracy. So we should not get stuck with Section 10 is what I'm saying. We should not. 10 is a source. 10 is a source for the purpose of, which is an exclusive source or an important provision which talks about how a relevant fact with regard to what was said, done or written by one conspirator can be used as against the others, is what it says. But there are different ways in which it can be collected by the court in the course of collecting the evidence, in the course of recording the evidence. Then you have to allow the prosecution to record it in that way, and then finally you will have to see or employ Section 10. You should not bring in Section 10 in the beginning itself, is what Justice P.N. Prakash would have said in the judgment. I thought that's a very important judgment, which is more practical also, to follow. So that's what I wanted to say. So with this, from here I would want to get into the illustrations. I think you must have got a broad idea as to where we stand in cases of this nature. So I'll now go into the illustrations. Yeah, so I have something like 6 illustrations which I have tried to, yes. I would request all of you to carefully see what is there in the first case is, what I have done is that I have tried to basically broadly have 2 types of cases. One is on the white collar and the other is the offense against the body. So basically I tried to see where it is more easier to establish, where it becomes very difficult to establish. That is what I have seen. Facts are, the case of the prosecution was that A1, an employee of an NCC directorate, and A2, who is a proprietor of a medical store, conspired to fabricate 3 cash memos for medicines for an amount of totaling up to 31 rupees 89 paisa. So just forget about that amount, which had not been purchased at all. And on the strength of these cash memos, A1 had prepared a false medical reimbursement bill and realized this amount from the government. A1 and A2 were friends. The total amount of money realized by A1 on such bills was so large that it had aroused the suspicion of the authorities, with the result that an inquiry by the CID had to be instituted, which brought the facts on which the accused were prosecuted to light. A1 and A2 were charged under 120B, 420, 467 and 471 IPC. A1 was also charged under the Prevention of Corruption Act. So basically, A1 is the government employee, A2 is the proprietor of a medical store. Both of them were friends. A2 was giving certain medical bills to A1 without there being a real sale or purchase of medical bills. A1 was using these medical bills and he was getting the amount reimbursed from the government. Basically, this is the crux of the matter. Look at what evidence is available in this case. There is a charge of conspiracy, therefore that's why evidence. A1 admitted that he had obtained the payment for the medicines from the government. He had asserted that the cash memos were genuine and that they were given on payment of the prices of the medicines prescribed and actually purchased and taken. So, insofar as this reimbursement is concerned, it was admitted. It was an admitted case that it was a fact that these bills were submitted and the amount was reimbursed by the government. There was no issue on that. Then A2, proprietor of the medical store, on the other hand, admitted that the cash memos were really fictitious, meaning there was no actual receipt of cash and delivery of medicine. That did not take place. What took place was that there was a bill that was prepared by A2 and given to A1. His version, however, was that they were prepared at the instance of A1, who was in the habit of taking such cash memos every month on the pretext that he would otherwise have to give his whole salary to his father, who would not allow him to deduct some pocket money for himself and his wife without such cash memo. So what he said was, A2 said was, A1 came to me, he is my friend. He told me that you give these bills to me, and these bills will be as if I have purchased some medicine. By showing this, to that extent, I will knock off some pocket money from the salary, or else my father and my wife are taking away the entire salary from me. I am not getting pocket money, is what he said to him, and he believed, and he admittedly, A2 had given fictitious cash memos. That's an admitted case. Then, when A1 was asked to explain the version given by A2, A1 stated that A2 tells lies to save himself, and that medicines A2 gave him were not in his stock and accounted for. A1 further asserted that he had shown the medicines to the doctor who prescribed. So that's another version. A1 comes. He says that in fact I purchased the medicine. In fact I showed this to the doctor. Doctor was examined as a witness in this case. See, doctor says that A1 did not show him any medicine, and that there was no practice to see the medicines after they have been purchased by the patient, is what the doctor's evidence says. Then,
doctor will only see the bill.
His bill.
That's all.
No, when he is giving the essentiality certificate, he will only verify the bill, whether there is a prescription given by him.
Correct.
He doesn't see the medicine.
Medicine. Correct. Then, please come down. So these are the evidences that are available. These are the evidences that are. I'm sure that all of you understood. Junior members understood the facts of the case. The facts of the case are: A1 and A2 are friends. A1 is a government employee. A2 is having a medical shop. A1 had approached A2 and said that my entire salary is being taken away by my family. They don't even give me pocket money. So I'll have to create something for the purpose of getting this pocket money. Therefore, you please prepare some medical bills as if it has been spent towards it, and to that extent I'll reduce it and give the balance to my family. This is the version that was stated by A2. Insofar as A1 is concerned, he says, no, I had actually purchased the medicines, I had shown it to the doctor, and I have properly produced it before the government, and the government has reimbursed me. Now there are 3 or 4 evidence that are available. One is that it is it is established that it is a fictitious bill. It is nobody's case that it is a fictitious bill as admitted by A2. The doctor says that he has not seen any of these medicines, and it is also a fact that the reimbursement has actually happened. Now there is a charge for 120B apart from cheating and forgery. So any junior member can come up and say whether the conspiracy part of it is established. Yeah. Anyone?
You can unmute yourself and answer.
This is a very simple case. I thought I'll start with a simple case and probably I'll go with case with some more facts also.
In this case, conspiracy is not established.
No, Mr. Menon, I don't want you to answer it. And I know that you will answer it and give 10 judgments also. I don't want you to do that.
Because of you directly answers this.
I want some, because we have dealt with conspiracy, I thought somebody can. Somebody is getting it?
Ramshad was making some.
Anybody can, because I enabled anybody to unmute and can answer, then please mute again.
Sir, I think rather according to me, A1 has not committed. Reason is that against him there is no evidence, only that, see, if I go to the metal shop, my friend has given me the false bills. I am not aware whether these are the real cash memos or whether it is a false memos. So he gave me, I gave it to the government and I got a reimbursement. I did not check whether the bills were proper or not. And as it was stated by sir, just now Ramkumar sir, that doctor will only see whether the bills were given or not. He will not check whether these were the bills.
When you say I, who is that you are representing?
I'm talking about A1. So according to me, A2 is liable, but I don't think so A1 is liable, because A1, I mean, he may take the stand that I was not aware about the bills, whether it is genuine or whether it is false or whether it is fictitious. He gave me the bill. I purchased the medicine. I showed it to the doctor as per the prescription. Doctor has not denied the prescription. And later on, he is also saying that I got a reimbursement from the government. So here, I don't think so any role of A1 is there, according to me, yes, sir. A2 I think is liable, but A1 I don't think so. That's
A1, your ranking is A1 is the shop owner, and A2
no, A1 is the government employee.
According to you, he is not liable, is it?
Yeah. I think A2 is liable for making the forged bills. A1 I don't think so, according to me, sir. Thank you.
No, sir. Conspiracy part not established. Bhagwan Keshan case.
Please don't go to case laws, please. Just stay on this. Just stay on the principle.
First principles.
Just stay on the principles. Let's not really take into consideration case laws here.
We approach the problem on first principles.
Okay, my first question will be: is there meeting of minds between A1 and A2? See, that's the starting point, correct? See here. Where did the conspiracy start? As I told you, as I was telling you for such a long time, conspiracy started when A1 had developed that intention to use fictitious bills for the purpose of getting reimbursement. That's the starting point. That's the starting point, because you'll have to know where it starts. It started there. After that, what he did, he went to his friend A2 and he told A2 that he requires certain bills, certain medical bills. According to A2, A1 had told him that he requires these bills for the purpose of showing to his family, and to that extent taking some money out of the total salary for his pocket money, because his grievance is that his father and wife are not giving him any pocket money. That's the version of A2. So what gets established is that A2, even according to A2, there was no payment of money and there was no delivery of medicines. So that is very clear. But thereafter, what happened? Thereafter, A1 had used this medical bill and he had got the amount reimbursed from the government. So the government had reimbursed the amount. Which was not actually spent by A1 at all. It was based on the bogus bill. So these are the facts which gets established. For conspiracy, what is the meeting of minds with regard to the offense to be committed is the test. That is the test. So if it is an offense per se, for the purpose of committing an offense, then first we have to see whether the preparation of the bogus bill by itself is an offense. That is the starting point. If that itself is an offense, then we don't need to go to the last step at all. If it is an offense, obviously the offense of conspiracy will be established. The question is whether this preparation of bogus bill is an offense.
Yes,
Is
yes.
it a forgery?
That is itself is an offense.
Is it a forgery?
Sir, it is offense. It is offense, but how can we say that A1 has aided for that offense? A2 suo moto must have also made the bills, na? That's what I'm saying. Here there is nothing evidence I can see that A1 has instigated A2. That is only the version of A2.
I think
there is no any independent.
You are getting into some words which are not required for a conspiracy. Instigation. See, that's why I wanted you to participate. This instigation, all that is not here. Meeting of minds is the word which you have to use. A1 and A2 were friends. That is admitted. A2 has already, A2 says that yes, it was bogus bill. There was no cash. There was no medicines that was actually supplied. That is established. 3. A1 had used that bill for the purpose of getting reimbursement. Is there a conspiracy on this? So now what is the test which I was telling you under section 10? Section 10 was used, one word that was used in section 10 was, yes, reasonable ground to believe. Is there? Is it there or is it not there?
Yes. Ground is there to believe since they are yes. It is there, sir.
It is there. Okay.
No, sir, there must be that two or more person agree to do a thing.
Yes.
The provisos say that no agreement except an agreement to commit an offence shall amount to a criminal conspiracy. So there is no agreement at the initial stage.
Why? Why?
There was no agreement to make the forgery or cheat the government at the initial stage by A1.
No. A1 wanted to use this bogus bill for the purpose of getting reimbursement from the government.
Sorry, on the part of A2, there was no intention by A2.
Before that, I want you to answer whether that bogus bill that was prepared by A2 by itself will constitute an offense of forgery. If you, there lies the entire issue.
Yes, sir.
Yes, that is itself is a forgery.
Is it a false document?
Yes.
Yes, sir.
How?
Itself is of an offense.
How? You have to know you have to know the ingredients of it by reading 463 and 464. So there must be basically two things. One is that there must be the preparation and it must have been used. There are twin tests. There are twin tests for that. It must, for instance, you forge your report card and keep it with yourself. Till then there is no problem. You keep forging your father's signature in a piece of paper. You do it, you practice it in your house. You keep signing his, because you know what marks you are going to take. So you keep practicing it and the paper is with you, no problem. The moment you put that signature into the card and report card and submit, what happens? There is an effect to it. So in all these cases, there is a twin effect. One is the first, the first step of preparing it, then using it. So in this case, see, this is a very simple case. This is very, very straightforward, simple case. But look at how we are able to, get into a lot of questions into that. Yes, Mr. Menon, what is your view?
I would say, number one, forgery, if you can say it is forgery, but at the same time, it's too hard to believe. Because I would be biased by reading the Supreme Court judgment because it's a direct ruling which was considered in 1974. So in that particular case, what happens was Supreme Court says it is too hard to believe that the proprietor of that medical store who has been so interested, he could act in such an irresponsible manner. So as to adopt that giving of fictitious bills and all. and subsequently 120 has to fail. There is no question of 120. I'm in a criminal conspiracy. It can never be.
Okay. Okay. So what happens is that this was not held to be a forgery first. The trial court held that it was not a forgery. No offense of forgery was made out, was what the trial court had said. So therefore, the only thing that went on was 420. 420 was the only offense where, because there is a wrongful loss that was cast to the government. So 420 IPC was the only offense that went on. Now you look at what the Supreme Court is saying on this. Yeah. A1 contended before the Supreme Court that there was no evidence against him and that the conduct, account books and statements of A2 could not be used against him. Supreme Court at the outset rejected the contention of A1 as the same overlooks the provisions of Section 10 of the Indian Evidence Act. However, by applying the fundamental principle that criminal conspiracy cannot be inferred from mere suspicious circumstances, the court acquitted both the accused from the charge of criminal conspiracy. So that goes. So therefore, that is why I said that one is a relevant fact which gets into the attention of the court. Where what is the test? The test is that it's reasonable ground to believe is the test. But when it comes to establishing the substantive offense, then the test is beyond reasonable doubts is what I said. So therefore, now see what the Supreme Court is saying. There is rejected the contention of A1 as the same overlooks the provisions of Section 10 of the Indian Evidence Act. To that extent, it was satisfied. However, by applying the fundamental principles that criminal conspiracy cannot be inferred from mere suspicious circumstances, court acquitted both the accused from the charge of criminal conspiracy. Then, the court found that though it was clearly established from the evidence on record that A2 had prepared fictitious cash memos, as he actually admitted for some purpose which could be assumed to be ulterior and improper, it was difficult to hold on a slender evidence on record that the purpose of this fabrication alleged by the prosecution had been established beyond reasonable doubt, or that a conspiracy between the two accused to prepare fictitious cash memos for that purpose must necessarily be inferred from the suspicious circumstances proved against them. Then, although A2 did not prove his defense, yet he was entitled to the benefit of the principle that circumstantial evidence must be of such a nature as to exclude any other inference except that the guilt advanced by the prosecution to sustain the conviction. Consequently, A2 was given the benefit of doubt and the conviction and sentence against him were set aside. He was acquitted of all charges. A2 was acquitted of all charges. But when it came to A1, the court held that the charge of 120B must fail against A1 also. Conviction and sentence of A1 under 120B was set aside. However, the court maintained the conviction of A1 under 420 and under section 51D and 52 of the old act of the Prevention of Corruption Act. Court found that A1 had fraudulently realized the sum of rupees, so and so, so and so. So this is the one which came out of that judgment. So basically, it is like this: if A1 had purchased a knife from the shop of A2, that shop is owned by his friend, and he says that he requires this knife for the purpose of using it in his kitchen or for the purpose of using it in his garden, and A2 gives that knife to A1, ultimately A1 with that knife had committed an offense. Then what happens is that you rope in A2 for having sold that knife is the question. So that is where that meeting of mind comes. Insofar as A2 is concerned, he had given that knife to A1 on the basis of what A1 told him, whereas A1 had a completely different intention for it. But the scenario will be completely different if A1 had told A2 that I want to finish off one particular person, I need a knife. A2 had also given that knife to A1. There, the fact that A2 had given that knife to A1 will constitute an offense of conspiracy. If you are able to understand this. Now you put it to the present case. At the time when the bill was given by A2 to A1, A1 had given a particular version to A2 for the purpose of taking that bill. There was no meeting of minds as between A1 and A2 for the purpose of committing an offense of getting a false, bogus reimbursement from the government by using the bogus receipt. So therefore, the Supreme Court said that when it came to establishing the offense of criminal conspiracy, the material that was available before the court was not enough. That's what it said. Then get into the second. This is one another interesting case. See, the deceased man was a former lover of A2. He broke his relationship with A2 after his marriage around so and so. A2 developed illicit relationship with A1. So the deceased wife developed illicit relationship with A1. A sub-inspector of, he is a sub-inspector of police. He is a married man whose family was living in a different place. So she started living with him as his concubine. Though they were living in a rented house, they also used to stay in the official quarters of A1 attached to his police station. Out of this illicit relationship, A1 and A2 got a son. In early 87, the deceased accidentally came across A2 and revived his old intimacy and love affair with A1. Upon coming to know of the same, A1 made up his mind to put an end to the intimacy by causing his death. The prosecution alleged that A1 and A2 hatched a conspiracy to murder the deceased, and that in pursuance of that conspiracy, A2 met the deceased at a bus stand on so-and-so date and took him to the house taken on lease. So this is on the first day on 18/7. Then the next day, on 19/7/87, A2 used a deceitful means and took the deceased to the official quarters of A1. A1 and A2 caused his death by suffocating him. Thereafter, A3 and A4 joined and with the help of A4, A1 and A2 removed the body of the deceased from A1's house and took it in a boat in Pamba River. A4 drove the boat to some distance, wherein A1 cut off the head from the body of the deceased with the knife supplied by A4. The severed head was thrown in the river, and after proceeding further, the headless body was also pushed into the river. An FIR in a man missing case came to be registered. A3 surrendered on so-and-so, and thereafter A1 and A2 were arrested. A4 gave a confession statement later, and he turned as an approver and was granted pardon under section 306. A1, A2 and A3 were committed to the sessions court to stand trial for various offences under the IPC. So this, I think the facts are clear if you read it. Then evidence. Testimonies of witnesses were relied upon to prove that the deceased was in intimacy and so and so, so and so. And the witnesses spoke. The following circumstances were relied upon by the prosecution to bring home the charge of conspiracy. What are they? A1 and A2 had a revengeful motive to murder. Second, the deceased was last seen in the company of A1 and A2. 3. The dead body of the deceased was removed from the quarters of A1 to a boat, dismembered and thrown into the river. 4. The hairs collected from the quarters and the boat were found to be similar with the scalp of the hairs collected at the time of the postmortem examination on scientific examination. 5. The deceased was made to write 2 inland letters, postdating them so as to make it appear that he was alive on the date of those letters. These letters were also materials. Then, can you move up? The deceased, the recovery of MO3 on the basis of the information that was furnished by A1. Then, can you push it up? Yes. Now, these are the materials. So I'm sure that all of you have gone through it. I'll put it simply. Case is very simple. The case is that A2 was the wife of the deceased. She had come away from him. She started living with A1 as his concubine because A1 is already married. Then they both had a son. A1 and A2 had a son. All of a sudden, A2 comes in contact with the deceased who was her lover earlier. And it is said that she met him, and on the first day they went into some rented house. On the second day, she had taken him to A1. And the case is that A1 and A2 had killed him by suffocating him. And thereafter, A3 and A4 get into the scene. A3 helps the body to be removed from the quarters or police quarters of A1 to the boat belonging to A4. And when they were taking the body in the boat, the head was chopped by A1. It was thrown at one place. Then the body was thrown into another place. And there is a confession statement that is available that has been given by, A4 had turned as an approver and he had described it completely. There were evidences to show that A1 had actually rented the boat of A4. There were evidences to show that the deceased was seen in the company of A1 and A2. That is the last seen theory was there. And there was also the evidence of the approver that was available. Then MO3, which is the weapon that was recovered, was also recovered. All these materials are there. Now tell me whether conspiracy has been established.
Yes.
Someone can come. Someone can.
Yeah, conspiracy is the.
According to you, the conspiracy is established, correct?
Yeah.
Yes. Yeah. Anything else? Any other answer? See, the reason why I am putting this is that for a prudent man, it is very, very clear after reading the facts that what more is required for me to establish conspiracy in a case of this nature. Because there is an illicit relationship between A1 and A2. A1 did not like A2 reviving the relationship with the deceased. A2 had brought the deceased to the quarters belonging to A1. And then the deceased was found last seen in the company of A1 and A2, and the death actually happened because there was a scientific evidence to prove that the hairs collected from the quarters and the hairs that were collected from the boat were matching. And thereafter, the body was recovered from Pamba River. Then the evidence of the approver, A4, who turned into an approver in this case. So when we look into all these things, what is ultimately the process of deciding whether there is a conspiracy or not? It's an inference which you derive upon seeing all the facts that have been placed before you. That is what you have to derive out of it. The inference that you are now deriving is that there is a conspiracy, correct? There looks like a conspiracy. At least there is a reasonable ground to believe that there is a conspiracy, correct? A3 and A4, leave it. A3 and A4 got into the scene after the incident. A3 and A4 got into the scene. The conspiracy is as between A1 and A2. A3 and A4's their disappearance, 201. So leave that.
No, A1 and A2 had a conspiracy, definitely.
Had a conspiracy. That is what I also feel.
Yes, sir, because both of them were anxious to see that the other person is no more. Other person is killed. That is how it happened.
Okay. Any other answer?
The question is actually who killed the deceased?
Yes.
A1 or A2 actually killed the deceased?
That is the overt act. That is the overt act part of it. Overt act part of it. I am talking about the conspiracy part of it.
Yes, then definitely there is conspiracy between A1 and A2 alone with respect to murder of the deceased.
Okay.
Because without conspiracy, it cannot happen.
So therefore, it is irrelevant as to who really killed it.
I mean, from the facts given by your lordship.
Yes. Yes, Menon.
Again, I will say there is no fact of conspiracy because after I have read the judgment, this is a direct judgment during 2000. So I would be
today the challenge. Today, sometimes I feel that
what is it? Citation?
Yes.
Citation is AR 2000 Supreme Court 3323. It is State of Kerala versus Sugadan.
Yes. Yeah. 2008 SCC page 203. Please see what the Supreme Court is saying. This is
probably they would have been convicted invoking section 34, not 120B.
No. Just see.
That was also not there.
Yes. That was also not. See, the reason why I am citing such judgments is that, see how difficult it is to establish this 120B is what I am saying. See, it looks very, very easy to understand it, but then when it comes to convicting, please see what the court found that the evidence on record established that the deceased was having an intimacy with A2 during his student days. That the deceased later got married and they broke up, and that a few months prior to the marriage, the deceased ran into A2 and attempted to revive his old intimacy. She had invited him to the quarters of A1. The court found that from this, it cannot be said to have proved that A1 was aware of the revival of the intimacy between A2 and the deceased, or that by inviting the deceased to the quarters of A1, A2 had any prior intention to finish off the deceased. This is the finding. The only question which will arise in your mind is that why at all the deceased was taken by A2 to the quarters of A1? There was nothing between the deceased and A1. It is not a case where A1 knew deceased earlier, therefore a meeting was arranged with him. No. There was no reason why A1 had to meet the deceased. But the case is A2 took the deceased to A1. That is a conduct which, according to me, is very important. But it was held that it cannot be said to have improved. A1 was aware of the revival of the intimacy between A2 and the deceased. Then the court found that the mere fact that one of the witnesses spoke about the deceased telling him that he had been invited by A1 to her house cannot be stretched to hold that such an invitation was in furtherance of a conspiracy. So there was also a witness who had spoken saying that he had informed, that the deceased had informed him before he left, that it was on the invitation of A2 that he is going and meeting A2. There was an evidence to that effect. But the court said that we cannot stretch it to such an extent to show that there was that it was in furtherance of the conspiracy, is what was said. Then 3. The court also found that there was no evidence to show that A2 was averse to the revival of her relationship with the deceased, or that she had shared with A1 about her love affair and its revival by the deceased. The termination of the early relationship would not be a cause for A2 to share a common intention of committing the crime when she was happily living with A1, though without marriage, and had borne him a son also. Even if A1 had known about the intimacy, that did not warrant an inference that A2 had cause or occasion to agree with him to commit the murder. This is the other reasoning. This is the other reasoning that was given. Then, that the deceased was last seen in the company of A1 and A2 would only prove his death when he was with the aforesaid persons. This cannot be sufficient to conclude that A1 and A2 had agreed to kill the deceased before he came to the residence of A1. This is the next finding. Then the evidence on record showing that the screaming of a woman, this was the one which had actually acted in the mind of the court. There was evidence to show that there was a screaming sound of a lady that came out of the quarters belonging to A1, and that screaming sound was the sound made by A2 after the incident. That murder was when it was taking place, and some witnesses had said that they were able to hear a screaming sound from the quarters of A1. Look at that. Evidence on record showed that the screaming of a woman not only suggested the presence of A2, but her reluctance to share the common intention to kill the deceased, or on seeing him being killed to be horrified. This really have acted upon the. So therefore, you look at this. There was everything to show that this would not have happened without the active. See, the deceased. There was no reason for the deceased to go and meet A1 at all if A2 had not taken him to the house of the quarters of A1.
Yes, sir. That is right.
There was no reason at all for the deceased to go and meet A1, because it is not a case where he went there on the invitation of A1. No, he was in connection with A2. The case is A2 took him to A1, and A1 and A2 were admittedly present at the time when this offense was committed. So therefore, it was the duty of A1 and A2 under section 106 of the Evidence Act to, because it was within their knowledge and they had to say what had actually happened. But what tilted the entire balance is the screaming sound which came out of the quarters of A1. Therefore, the court said that A2 was not for killing the deceased. She was horrified by the killing of the deceased by A1, and therefore she had screamed, which made the court to say that there was no meeting of minds with regard to conspiracy to kill the deceased as between A1 and A2. This is...
Could it not be a far-fetched imagination?
Because all this, everything was contributed by A2 alone.
Yes.
And you please see, A2 traveled with this dead body. A2 traveled along with A1 and A4 in that boat. And A2 was a witness to the head being chopped off and thrown into Pamba.
No scream.
The most affected person will be A2 because she doesn't want to revive the relationship with the former husband or the former lover.
Yes.
Because she is happily with A1.
Correct.
Probably
Correct.
At the instance of A1, bring him, let us see. So, at the request of A1 alone, you could have brought her also.
And in fact, if she was genuine to really revive the relationship, she need not have taken the disease to A1 at all.
No, she could have enjoyed both.
And see, of course, the overt act of murder might have been committed by A1.
A1, correct.
Seeing the brutality, A2 might have screamed.
Correct. But
she had not prevented him from doing it also.
This is how we appreciate murders. We appreciate
trial court appreciate how the Supreme Court acquits.
So what I'm saying is, this is a case where you are able to see conspiracy on the face of it.
Even if there is no conspiracy, section 34 can be invoked.
Correct.
Leave alone that. Which law says that conspiracy cannot be inferred?
It can only be an inference. That can only be an inference because no direct evidence will be normally available.
Even Kehar Singh's case, they very clearly said it's all hatched in secrecy.
Secrecy. But at the same time, sir, see, this was considered in this case also. Conspiracy, of course, it can be inferred. Kindly see, in this particular judgment, the judgment in B.C. Shukla, and even after this judgment also, I can tell you another judgment also. See, as far as this case was concerned, the court goes on to say that the circumstances which are mentioned, which Justice N.Anand Venkatesh had displayed, all those circumstances, that even if taken at their face value, it cannot indicate the meeting of minds. Of course, that indicates something, and the Supreme Court goes on to hold what they have held in B.C. Shukla. A few bits here and there, that cannot make conspiracy, which again we stand settled in that Parliament attack case of 2005, to year 2005 Supreme Court 600. Absolute Guru.
Then this is how we appreciate or disappreciate evidence.
That is why I said that it is good to discuss about a conspiracy as a theory. It is all very nice, where we can sit and sort of intellectual exercise can be done by interpreting.
Probably that is the reason why the police is not averse to us 120B and adding 34. 34 easy for them. 34 easy for them because intention, some act, presence, thereafter complying. Circumstances, all the circumstances cumulatively will go to the both these alone can do it.
The other day, Justice Nagamuthu admitted that if it is 5 and above, 149. Less than 5, 34. That is the rule.
That's the general tendency.
That seems to be the rule.
That's the general tendency which we follow.
Sir, in this case, the theory of conspiracy is subsequently proved.
No, the conspiracy must be prior. Normally, the common intention and the conspiracy must be prior one. Subsequent proof, maybe a planted also can be. That is subsequent proof regarding that.
Sir, what I mean to say is not now. But subsequent event is that both A1 and A2 are living happily now together.
The contact. You mean to say the contact?
Now they are A1, at present, A1 and A2 have no enmity in between and they are living together as husband and wife.
Yes.
That is the present situation.
The man speaking was the investigating a part of investigation, Mr. Devarajan. He is now a lawyer.
That is right. The accused was one of my senior officers.
A1.
Anyway, we'll go into the third one. We have time, Mr. Shah?
Oh, yes.
Yes. Okay.
Definitely. Yeah.
Look at this case. The case of the prosecution was that the deceased, who was a young unmarried woman of 24 years of age, developed an illicit relationship with A2, with the result that she became pregnant. She insisted that A2 should marry her, but her request was declined on the ground that the marriage was not possible because the deceased and A2 belonged to different religions. A2 is stated to have quarreled with the deceased, for which she filed a complaint against him at the police station. The deceased did not accede to the advice of A2 to have the child aborted. On the date of occurrence, she is stated to have gone to the hospital at about 11 a.m. for a checkup. And on her way back, she visited her sister PW9 at about 2:30 p.m. After she left the residence of her sister, she was fatally stabbed by A1, who had followed her from the bus stop where she had alighted from the bus. After inflicting the stab injuries, A1 left the place of occurrence. The offence was alleged to have been committed by A1 in conspiracy with A2, who wanted to get rid of the deceased. The deceased was in the advanced stage of pregnancy at the time of her death. A1 was arrested on the next day. After recording his disclosure statement, the weapon of the offence was recovered from the bushes where he had allegedly hidden it, and the same was assigned MO1. The dress worn by him on that so-and-so is MO so-and-so with the murder. Then go to the evidence. These are the facts of the case. Go to the evidence. PW9's sister deposed that deceased had told her that the pregnancy conceived by her was through A2 actually. I think it should be A2. A2 admitted the paternity of the conceived child in the initial stage, but denied the paternity attributed to him 6 months thereafter. The trial court found that PW9's version about the first source of knowledge about pregnancy was inconsistent and unnatural. Trial court further found PW1 had no occasion to meet the deceased at all. Then PW6, the mother of the deceased, stated that she came to know about the pregnancy of the deceased only when she tried to fix her marriage with some person, and the deceased told her that she was in love with A2. Her testimony was not that the deceased conceived the child from A2. She said that the deceased and A2 were in love. They knew each other for a period of 2 years before her death. According to her, the marriage between the deceased and A2 could not be solemnized as they belong to different religions. She never saw the deceased and A2 talking, as according to her, they used to talk only in her absence. PW6 did not state that A2 wanted the child conceived by the deceased to be aborted. This is evidence of the mother. Then PW6 further stated that on the date of occurrence, both the accused were sitting near her house on some timber logs at about 2 p.m. But at 2:45, she saw only A1 washing his knife near the stream, which is on the southern. Yes, take it up. Southern side of her house. What happened between 2 and 2:45 is not known to the witness. Her deposition is mainly with respect to so and so. Then PWT2 is the neighbor of the deceased stated that she had known about the pregnancy from the deceased herself. According to her, A2 had quarreled with the deceased in connection with the pregnancy. Despite denial of A2, the deceased was stated to have asserted that she did not have sexual intercourse with anyone other than A2. In her cross, the witnesses stated that A2 never threatened the deceased. She admitted that A2 had apparently told the deceased that he was not the father of the child in her womb. The witness conceded that she had no direct knowledge about the relationship of the deceased with A2. Then PW3, who is the neighbor and husband of PW2, was declared hostile as he did not support the case. PW5 stated that on the date of occurrence, he had seen A1 at about 2 o'clock in the afternoon. He replied as to whether he had seen anyone else going through the road while A2 was talking to PW4. Witness replied, I have not noticed. Then PW7 states that on the date of occurrence at about 2:45, A2 had called him. He told him to come after some time. He went there and talked to A2. PW8 and PW10, he saw the deceased getting down from the bus at about 2:30 p.m. She had gone to the house of her sister, PW9. He did not see A1 with A2. He saw only A2, PW8, PW10 and some other people. This is what he says. Then PW8 stated that he saw A2 on the date of occurrence at about 2:30 p.m. at the gate of his house. Both he and A2 had conversation on the steps of his house. A2 was there for about half an hour. Then PW11 says that both the accused had come to his shop at about 1 p.m. and each of them had one plate of tapioca and so on. So there is no eyewitness in the case of the prosecution sought to prove its case by leading the following circumstances. These are the circumstantial evidences available. Deceased and A2 are residents of so-and-so, were engaged in a love affair and had quarreled when the former disclosed that she was pregnant and she also disclosed her pregnancy to her mother, PW6. Deceased requested A2 to marry, that was turned down by A2. When the close relatives of the deceased persuaded A2 accused to marry her since she became pregnant through him, A2 proclaimed that he would not allow the deceased to deliver the child. A2 manhandled the deceased in connection with this dispute. That was seen by her neighbors and there was also involvement of the police. The conduct of the accused on the fateful day, accused were seen together on the date of occurrence by several persons and from PW11's tea shop they had taken food. A1 was seen washing his face and hands at the so-and-so place after the place of occurrence about the occurrence, and dress worn by him on that date have been removed and identified as so-and-so. A1 was seen at about 3 p.m. on the date of occurrence while he was going through the certain place. Recovery of MO1, recovery of MO25. Immediately after the incident, the accused were absconding and the arrest of so-and-so. This is the circumstances. Now, these are the evidences that are available before the court. Is there a conspiracy between A1 and A2?
Yes, it is completely visible, sir. Absconding, and secondly, they were together. And why A1 will kill deceased? She was not pregnant from A1. Because of the A2 only A1 has committed, there is a criminal conspiracy between A1 and A2.
Okay.
It is visible.
Okay. So there is a conspiracy here. Okay. Anyone else?
No conspiracy.
Why?
The fact is, didn't see it.
Look at the basic facts in this. A2 had a relationship with the deceased. Deceased had conceived and she was insisting A2 to marry him. He was refusing to marry her on the ground that they belong to different religions. A2 was insisting that the deceased will have to abort the child. And earlier, the issue had gone before a police station where a complaint was given by the deceased against A2 with regard to their relationship. So the relationship between A2 and the deceased there were sufficient materials to show that there was one deceased. There is no dispute regarding that at all. The only issue is whether there was a conspiracy between A1 and A2 whereby A2 on a conspiracy with A1 and A1 thereafter had killed. A1 was the one who actually caused the stab injury to the deceased, whereby she died. The issue is whether there was a conspiracy between A2 and A1. And nobody says anything with regard to the prior meeting of the deceased with A1. A1 had nothing to do with the deceased in this case. It would be too much a coincidence for A1 to just pick up a knife and start stabbing some woman for nothing. It's not a case that A1 is an insane person. So therefore, it would be too much to really infer that it was a coincidence that A1 all of a sudden took a knife and stabbed the deceased.
There is no provocation also made for that. No evidence.
Yes, the evidence shows that she got down from the bus. A1 followed her, stabbed her. Followed her, stabbed her. And there was evidence to show that A1 and A2 had food together in a particular shop about which a witness is speaking. Why would A1 kill the deceased? What was the provocation for A1 to kill the deceased in this case? That's the most important factor. That's the most important thing. Why would all of a sudden, from nowhere, somebody will come and kill? With regard to the identity of the murderer, there is no issue at all. The only issue is whether there was a conspiracy between A2 and A1. And as everyone says, that the conspiracy is hatched in secrecy. We do not know what A1 and A2 were talking. We have to infer it only from, that's why I said that it's a reverse engineering process. We have to start from the incident and go back and see what all has happened between them. So on the face of it, if you look at it, it will look like that A1 could not have killed the deceased if not for the conspiracy with A2. There was no other reason for A1 to have. So please see what the Supreme Court is saying in this.
No conspiracy, says the Supreme Court.
Yes, sir.
Citation?
Sharath, will you?
It is AR 2001 Supreme Court 175. Actually, this was a clear case, but still the Supreme Court, maybe in that particular case, it was like that because Supreme Court goes on to say several things, saying that there was no suggestion like this, there was no suggestion that.
Please look at the findings which I have underlined. Just to look at the findings that I have underlined. In the absence of an evidence suggesting the existence of circumstances of insistence of A2 for abortion, an important link in the chain of circumstances attributed against him is missing. Even otherwise, motive by itself cannot be proof of conspiracy.
Not
No, in the circumstantial evidence, motive also, if other things are proved.
Correct.
This is a link.
Correct. So it says there is no evidence to show that A2 was insisting for this abortion. So therefore, they find that there is a that the link is getting cut there.
No, assuming that he is not insisting for an abortion, the fact that she was insisting for the marriage and she was refusing itself is a ground for that. That also may be a reason why he want to avoid her.
Next, there is no suggestion, much less a legal evidence to the effect that both the accused were so intimate, which would have compelled A1 to agree to be a conspirator for the killing of the deceased at the instance of A2. A1 is also not stated to be a habitual criminal. There is no suggestion of A1 being hired for the purpose of killing the deceased. So this is the next find. So therefore, if somebody has to kill, there has to be a very close relationship between the conspirator and the actual killer.
Yes.
Then, if the prosecution witness does not suggest even by implication that both the accused were together on the date of occurrence, the statement of the witnesses may probabilize the presence of both the accused together, but does not prove beyond doubt they were together near the road at the place of occurrence on the fateful day. Assuming that they were together would not necessarily lead to the conclusion that they met in furtherance of a conspiracy to murder the deceased. This is the next finding. Then, prosecution did not succeed in proving his circumstance beyond reasonable doubt. Conviction of A2 on the basis of existence of an alleged circumstance cannot be justified. A2 was entitled for benefit of reasonable doubt. The court further held.
If that be the case, how the court convict A1?
A1 because overact. That's what I'm saying. Overact.
No, that is also, there is only circumstantial evidence to show he committed it.
The High Court was
all those benefits can be given to A1 also.
That's why I said that there is a conspiracy and there is a resultant offense. Basically, when there is a resultant offense and there is evidence to show regarding that overtake, then the court goes ahead and see. In many cases, this is happening. In many cases, the main conspirator just goes scot-free. Many cases.
No wonder police are reluctant to include 120B.
In this case, actually,
the ultimate conclusion is this final.
No, even they are not able to connect under 34 also. That is the difficulty.
It's a clear case actually, but just see how the Supreme Court by evidence. Much of evidence is not discussed, and they merely go to say it's not conspiracy. This was clearly conspiracy was there.
So let us go to the next one.
Yes.
Case number 4. Yes. This is a case where the deceased man was the husband of A2, who was his first wife. A2 left him after some years and stayed with someone else. The deceased married for the second time, but the second wife also died. The deceased married again, which is the third marriage, married again. After this marriage, A2 came back with their son, PW4, and stayed with the deceased. She went away many times and was living with the other man. At the relevant time, she was staying with A1. That's the main fact. She was actually staying with A1. On the fateful day at about 5 p.m. in the evening, A1 came to the house of the deceased looking for him. PW4 is the son. Is the son of the deceased with A1. PW4 stated that the deceased had not returned from the day's work and thus A1 went away. Deceased returned home at about 6 p.m. and at about 7:30 p.m. after taking food, the deceased was talking with his third wife and PW4. So deceased was actually living with his third wife and PW4's son from the original marriage was also living. At about 8 p.m., A1 came again, requested the deceased to come out of the house, showed a brandy bottle and invited him for having brandy. Hence, the deceased and A1 went towards the backyard. While the deceased collected hay sticks and dropped them in the cattle shed, A1 poured brandy in a glass of water and also mixed some white material which looked like a camphor. At the request of A1, the deceased consumed brandy. A1 also gave the deceased a plantain, which was also taken by the deceased. Immediately thereafter, the deceased felt giddy, fell down, fainted. PW4 and the third wife of the deceased poured water on the deceased. Since he did not get up, they cried. Hearing which, PW2 and 3 went there. PW4 and the third wife of the deceased informed them that A1 gave brandy to the deceased, and immediately thereafter the deceased swooned. A country medical practitioner was brought, who after examining the deceased directed them to shift them to a hospital. When the deceased was taken to the hospital, he was declared dead. PW1, the VAO, rushed to the place on being informed. He inquired PW4, who is the son of the deceased and A2, and the third wife of the deceased, and ascertained that A1 and A2 had mixed poison in the brandy. This is the second version. that is the version of PW1. He ascertained that A1 and A2 had mixed the poison in the brandy and gave it to the deceased. Upon his report, FIR was registered under 302 IPC. Now look at the evidence.
Who was PW1?
VAO, Village Administrative Officer. Mr. Ramkumar, you are fine?
All right, no problem.
Yeah. PW1 is the Village Administrative Officer. During investigation, the IO seized the brandy bottle, tumbler, brass tumbler, polythene paper, and piece of white cloth. Some recoveries were made from A2 also, but they did not relate to the articles purported to have been used for poisoning the deceased. Prosecution put forth the case that A2 was staying with A1 during the relevant point of time. Testimonies of witnesses were relied upon by the prosecution during trial to buttress its case that A2 had a motive to kill the deceased. PW4, who is the son of the deceased, and A2 deposed that there were several instances in the past when the deceased was assaulted by A2 or by persons engaged by her. This is, please underline this. This was there. The prosecution submitted that there was no reason for PW4 to depose against his own mother, and that his testimony amply established the motive for murder. Then, this is the evidence that was available. Okay. Now tell me whether there is a conspiracy between A1 and A2. Simple. A1 is the person who is living with A2. A2 is the former wife of the deceased through whom PW4 son is alive. Deceased was living with his third wife and PW4 his son through A2. On the date of the incident, A1 had come to their house. He had gone to the backyard along with the deceased, poured brandy. After consuming the brandy, died. There is evidence to show that there is poison. There is evidence of the 45 evidence is available. Expert evidence shows there is a poison. There is medical evidence to show that the death was due to poisoning. There was evidence to show that A1 had come to the house. It was spoken by the lady as well as PW4. There is evidence to show that A2 had earlier fought with the deceased, and he was in fact beaten sometimes through the persons engaged by A2. All these was available.
But what is the occasion for A2 to come to the deceased? She had abandoned him.
A2 never came. A2 never came.
So how did she fight with the deceased?
Earlier there were instances in the past. See,
when they were living together.
Yeah. Basically, both of them seem to be living with many persons.
Sir, I think there is no criminal conspiracy because there is no question. I'll tell you, sir, why. Because sir, wife does not have question. She is already having affair with A1. She is very happily staying with A1. And when she was his former wife of the deceased, that time husband and wife fight. There is a small quarrel. Just because PW4, who is the son, who is stating before the court that yes, my mother has beaten or she has engaged some person, that does not show that she wanted to kill her former husband. So because I am considering the other Supreme Court judgments, which 3 we have studied till now, sir. So I feel, sir, wife does not have any role.
Now I have only one question for you. Why does A1 want to see? A1 is also happily living with A2. It is not a case where the deceased was attempting to somehow disrupt the relationship between A1 and A2. That is nobody's case. A1 was also happily living with A2. Why would A1 come and give poison?
Why was A2 visiting the deceased?
Yeah, that is also there. I don't
I
do not know the relationship between the deceased and A1.
There was a bad relationship or a violent relationship between the deceased and A2. That has been spoken to.
Thereafter, A2 never visited the
Correct. A2 was living happily with A1.
Okay. Then.
And it is not a case where the deceased was trying to disrupt the relationship between A1 and A2. A1 and A2 were living. Deceased, one woman and PW4 were living separately. Issue is whether there is a conspiracy as between A1 and A2, which ultimately led A1 come to the house and administer poison.
Whether A2 ever came to the house of the deceased and attempted to revive the relationship?
No. In that case, A2 cannot be a part of a cannot be a conspirator.
So it feels it is not a conspiracy, but I think Supreme Court would say that there is a conspiracy. I think so. But according to me, I don't feel there's a conspiracy. So I think Supreme Court judgment will be there is a conspiracy. I think so. Okay.
Yes.
Thank you, sir.
Thank you. Anybody else? Anybody else?
Because no incriminating circumstances are also brought against A2, connecting with any of the recoveries made or any of the recoveries made related.
A2 was not in the scene of occurrence. That's very clear.
Not
A2 was not in the, except the VAO's PW1 statement that A1 and A2.
No, that could only be a hearsay evidence because he is not an eyewitness.
Correct. The best evidence would be only from PW4 and the lady who was living with the deceased. And both of them never said that A2 was there in the scene.
After separation, she never tried to revive their relationship.
Correct. Now let us see what the Supreme Court says.
No conspiracy at all. That's what the Supreme Court said.
There can't be.
Yeah, that is Ranganayaki versus State. 2014, 12 SCC, page 5.
No, it is not 2014. It may be 2004.
2004, sorry. 2004. 12 SCC. 2004, 12 SCC. Page 521. 2004, 12 SCC, page 521. Look at the evidences that were dealt with and the findings of the One is motive to murder the deceased. 2, recovery purported to have been made pursuant to the confession statement of A2. 3, evidence of PW4, the son, that earlier A2 had instigated A1 to beat the deceased, the earlier incidents. Now, insofar as evidence finding in 1 is concerned, court found the alleged motive is not substantive. The reference to past incidents do not prove any intention to murder the deceased, much less than any instigation thereof. 1. 2. The court found that the purported recovery of articles pursuant to the disclosure at 27 is of no consequence because nowhere did A2 say that the same was used for the purpose of poisoning the deceased. 3. The court found that there is...
then it will be an incriminating circumstance.
That will not be admissible.
Correct.
That will not be admissible.
Correct. The court found that there is practically no evidence of any abatement to the actual act committed, that is the murder of the deceased. Sharad, this was a case where the charge was for abatement?
Yes, it was.
Yeah, that's the one. That's something which I want you to ponder upon. In this case, the charge was abatement. Charge was not for conspiracy. Admitted, one important factor that comes out is no problem, sir. One important fact that comes into consideration is that instigation is not possible in this case because PW4 and the lady who was living with the deceased did not talk about the presence of A2 at the time when the incident had taken place. So therefore, instigation is ruled out. That is ruled out. Now, what we have to see is whether, I'm just posing this question, if there is a conspiracy also under 107.2, leave the other thing, 107.2 conspiracy is there, and the court was not able to get a material to show that there was anything further done in this case by way of an abetment or instigation, but there is a conspiracy per se that is available, where there is no charge for conspiracy, there is no charge for a conspiracy, then the question is whether if you have the charge as 109 read with 302, can you punish the person for the charge of conspiracy? Or in other words, what I'm trying to say is whether you can consider the abatement as a larger offense and the conspiracy, which is a cognate offense, as a smaller offense, and then punish the person, because 464 of CRPC contemplates a situation of this nature. Here, the materials were all available before the court, and the abatement charge by itself within it included a conspiracy also. So if that is the case, whether at the end can the court convict under 120B is another question which I wanted to raise.
No, probably if the evidence is there to come to a conclusion that there was a conspiracy, merely because the word conspiracy was not mentioned and 120B has not been added in the chart. The materials are available to constitute the defense.
Yes.
Nothing wrong, because 464 says that can be possible.
Yes.
Only thing is the accusation must be there for the purpose of the accused to know that such an allegation is also against the accused to answer it. No prejudice should have been caused on account of that. That is a different thing, but here there is no evidence at all to connect to.
Under 464, even the absence of a charge is curable.
Yes, except that where it causes prejudice to the accused person. That is the
only
case.
thing is the allegation must be there.
Yes.
Failure of justice.
When you are writing the accusation, you must mention all ingredients of the offense.
Yes.
That is there merely because you did not put the particular section or wrongly put the section does not preclude the court from exercising the power of conviction, making the conviction a particular proper section.
That's right. That's right. So we'll go to one more illustration, or we'll stop with this.
No problem.
You can go ahead.
Yes.
You are making the discussion very lively.
In fact, this is how a lecture should be delivered, with reference to concrete fact situations.
Yes.
You apply the law.
Now, this is one very, very important case which I want to bring to your notice. See, the victim girl was a 9th standard student. She was staying in a hostel. A2 and the victim girl developed a love affair. Pursuant to this, there was the case of the prosecution is that there is a conspiracy between A2 on the one hand and A1 and A3 on the other hand. What is that conspiracy? A2 threatened X to elope with him in a bus. X saw A3 in that bus in which they were traveling. At the bus stand, when she got down, X found that A2 went missing. A2 was not there in the bus stand, he went missing. When X was frightened, taking advantage of it, A3 approached X, called her by her real name. Because what had happened is that missing link is A2 had informed X that she should identify herself as Y and not as X. You should say that your name is Y and your real name X should not be revealed. But A3, when he approaches the girl, the victim girl, he calls her with the real name, called her by her real name, gained her confidence, and he introduced her to A1. Then A1 gained the confidence of this X, and he took her to a lodge where she could rest for the night and then take the bus the next morning. Then A1 raped X in the room. Thereafter, X was raped by several persons brought by A1. When she was kept in confinement by A1, X was subjected to 67 rapes, including gang rapes during the period, and after her release, she reached her father. FIR initially was woman missing case, was registered and later altered to 366A, so on, so on. So read with section 34 of the IPC. After completing the investigation, charge sheet was filed against 41 accused persons, including A1. Then evidence. Yes, just X went missing on 16/1/96. Teacher PW 25 and friend of X, PW24, deposed that A2 had acquaintance with X. Then it was due to A2's threat that he would make nude photographs of X. X left the hostel on so-and-so day. The photo album with which X was threatened was seized. When X boarded the bus, A2 told her that he will be seated in the rear seat. X saw A3 also in that bus. This was the statement of the victim. At the next bus stand, A2 went missing. And when X was frightened, taking advantage of it, A3 approached X, called her by name, and gained her confidence. A2 vanished from the scene and directed A3 to deal with the victim girl. Then there was a conspiracy between A2, A3, and A1 to kidnap X. The girl was moved from the hostel only because of the role played by A2. After the girl boarded the bus, A2 vanished from the scene. A3 told X that she could consider A1 as a brother. X was taken to a lodge by A1, stating that his mother was taking rest in the hotel, and thereafter A1 committed rape on X. These are broadly the facts. These are broadly the evidences that were available. Now the question is, was there a conspiracy between A1, A2 and A3?
Yes, sir.
This is quite a very serious case. So therefore, yes.
Sir,
Definitely,
because
yes.
I will say about her love affair, with that boy. That boy did not even go to police when she was left alone in the bus. Why did not he go to the police and inform that she's been missing? And then he was out of the picture completely, her boyfriend.
Correct.
And I feel it is the plan between all these three boys, A1, A2 and A3. The boyfriend is also responsible.
Okay. Yes.
The sequence of events is clear, Your Honor, my lord.
Yes.
That's why there's a clear conspiracy between the accused. And like your lordship mentioned, there like train journey, further accused, they also joined.
Okay.
That's my point of view.
Okay. So let's see what the Supreme Court says. Yes. This is the case of Dharmarajan versus State.
Oh,
Kerala case.
Suryanali.
Kerala Suryanali.
2014 Criminal Law Journal, page 3162. 2014 Criminal Law Journal, page 3162.
No, I think it was there. It was not mentioned anything, but it was remanded, it appears. Only thereafter, I think that
Kerala High Court convicted.
Convicted. Thereafter, it was convicted.
Not this Dharmarajan, but the other accused. Dharmarajan was absconding. Dharmarajan.
What happened was, Suryanali, it was twice it was tried. Dharmarajan was not there earlier, but subsequently, because some of the persons were convicted by one judge, a special judge. That appeal was pending. Secondly, the absconding accused Dharmarajan was also caught.
Yes.
And he was tried. And he was also convicted, relying on certain evidence given in the first case.
Yes.
And both went here, and I think that here all were acquitted. First, I think it was all were acquitted.
Then Supreme Court remanded.
Supreme Court remanded for reconsideration.
Correct.
I think that 2014 is a case where the court did not go into the merits of the case, only found the court should not telescope the evidence given in the other case and then convicted all.
I just want to get into the findings of the Supreme Court on this, on conspiracy. Yes, I now understand that. Okay. But for the conspiracy among A2, A3 and A1, the event starting from X leaving the hostel would not have happened. Number one. Number two, if there was a real love affair between A2 and X, why should A2 disappear on the way?
Exactly.
The evidence would disclose that A2 had promised to marry X, and that on that promise he had taken X from lawful custody. Naturally, one would expect A2 to take her with him, even if he had no intention to marry. But A2 disappeared, and X was placed in the hands of A3. A3 succeeded in entrusting X to A1.
A2 was tacitly presenting her to other persons.
Correct. As directed by A2, X traveled in two buses. By the time it was night, she was trapped in such a situation where she could not escape. The presence of A1 and A3 at the bus stand at odd hours, the presence of A3 in the bus in which X boarded, to wherever X went and the vanishing of A2 on the way were all part of the conspiracy.
Yes.
It was A3 who introduced A1 to X then. Hence A1, A2 and A3 were members of the criminal conspiracy. Can you pull it up? To kidnap X from her lawful guardianship. So this was an open and shut case. But I know that many were wary about giving an answer to this. They were not very comfortable in saying whether there was really a conspiracy or not. But then if you don't say that there is conspiracy in this case, it's better that 120A is removed from the book. There is no requirement to have a 120A at all, according to me, thereafter.
Because one division bench acquitted them. That may be the reason for some of them being wary.
Yes.
Because no, in that time there it appears to the consensual rape. A consensual rape.
Yes. So insofar as I focused more on the conspiracy angle of it, and yeah. So what is there anything left, Mr. Sharad? There is one more case.
Sixth one.
Yeah. This is the last one. Is it fine? Is it okay?
Okay.
Yeah. See, in this case, what happens is the appellant S was the chairman of the subordinate staff selection board. V was the member of that board. The board was carrying out a recruitment process to fill so many vacancies in the post of physical education teachers. The test comprised of A, screening test, B, ground test, and C, vivos. To conduct the vivos, 2 panels were constituted, one headed by S, other headed by V. Mr. R.K., a candidate, was interviewed by S and awarded 7 marks for the vivos. R.K. had obtained 51 marks in the ground test, thereby taking his tally to 58. That is 57 plus 51. He was accordingly classified as below average. However, in the final mark list, R.K. was shown to obtain 13 marks in the vivos, and his total marks were shown to be 64. He was accordingly recommended for appointment. This discrepancy was later unearthed and an FIR was registered against S, V and RK for offences under 120B, 420, 468, 471 and 13(2) of the PC Act. Now look at the materials. Prosecution produced the following materials. 1. 16 witnesses from the board including K, senior assistant, and W, a senior assistant and the handwriting expert. K and W deposed that the merit list was in the handwriting of S. And the columns in which the marks had been recorded were in the handwriting of V. The opinion of the handwriting expert corroborated this fact. Then, so this is the case. This is the case. The reason why I had put this case is that when you look at this case, you will find that unlike a case involving an offense against the body, etc., in a case involving a white collar offense, you will find that you will be more comfortable in getting into the aspect of conspiracy. That is why I was trying to put this case also. Now this is the facts of the case. These are the facts of the case. Do you find a conspiracy between the 3 accused persons? Yes, I got one answer in the chat box as yes. Second one is yes. Okay. Let me go into the findings of the Supreme Court. Yes. This is the case in 2018-15 SEC 349. State versus Surender Mohan Katwal. The evidence of K, that is PW3, stated that he was conversant with the handwriting of S and V. He stated that the signatures in the document accompanying the mark list belonged to V, and that in the merit list, the last 4 columns appear to have been written by V. Then, the evidence of K was corroborated by W, who stated that V had written column 5 to 8 in the merit list in his own hand and were signed by both S and V. K and W also spoke about the remarks in the interview sheet, which were found to have been updated and written by S. Then, On a combined appraisal of the evidence of K, W, and also the handwriting expert, it was clear that the altered figures in the merit list had been written by V. The signatures in the merit list bears the signature of both S and V. 313 statements of both S and V admitted to have prepared the merit list jointly. Court concluded that it was beyond doubt that the author of 13 and 64, that is the altered scores, was V. On these facts, the courts have rightly held that the appellants have conspired to make the entry of the marks recorded by RK as 13 to so on. So when you look at a white collar crime, basically you will find that there is one more judgment to which I want to, if you have the time, just go through the judges, the Mehboob case. That is a case of this counterfeit case, where you will find that I am sure that all of you know about it, but it is more focused for section 27 of the Evidence Act, in order to Evidence Act for the purpose of discovery of fact. It was sort of a march of law which actually took place. When you will find that in that case also, in that case what happened was that there was a chance recovery of counterfeit notes from one A. And A confesses that he got it from B and C. So the investigating officer goes to B and C. Nothing was recovered from B and C, but B and C say that they got this from D and had given it to A. Thereafter they go to D. From D they were able to recover counterfeit notes again. D also confesses saying that he received it from E and F. Thereafter, the police goes to E and F. E and F arrested, and counterfeit notes were also taken from them. E and F says that the kingpin in this case is G. Ultimately, they go to G. The recovery takes place. So this is broadly the evidence that was available, apart from the report from Nasik to show that these notes are fake. These are counterfeit notes. These were the facts that were available. In that case, the Supreme Court said that the conspiracy theory has been proved. And they said that, so this is their judgment. Mehboob Ali and another was the state of Rajasthan, 2016, 14 SEC, page 640. Can you go to that relevant paragraph so that with this I will complete the. This is a very important judgment under 27, as all of you must be knowing. Yes, it is apparent that on the basis of the information furnished by the accused so-and-so, the other accused is arrested. The fact that so-and-so was dealing with forged currency was not to the knowledge of the police. The statement of the accused has led to the discovery of a fact and the arrest of the co-accused not known to the police. They identified him and ultimately led to the unearthing of the racket of the use of fake currency notes. Thus, the information furnished by the aforesaid accused persons in possession of so-and-so fake notes had been recovered. As per the information furnished by the accused Mehboob and so-and-so, memo so-and-so, the fact has been discovered by the police as to the involvement of so-and-so, which was also not to the knowledge of the police. Police was not aware of the accused so-and-so, as well as the fact that he was dealing with fake currency, which were recovered. Thus, the statement of the aforesaid accused Mehboob and Feroz is clearly saved by 27. The embargo under 27 of the Evidence Act was clearly lifted in this case. The statement of the accused has led to the discovery of a fact, proving complicity of the other accused persons, and the entire chain of circumstances clearly make out that the accused acted in conspiracy as found by the trial court as well as the High Court. This is one case where the material that was available was the fake notes that were seized, the confession of the accused persons, which were brought in under section 27, and the report of Nasik. These were the important things that were available. But the court, on analyzing the entire facts of the case, was able to infer that there was a conspiracy between the accused persons. So So basically, I think I've overshot the time. But what I want to say is that this probably is the reason why the prosecution is sort of wary to bring in 120B as a charge in a given case. They find it more convenient to have 34 or 149 because it will be more easier for them to prove it with the overt act that is available under 34 and 149. 120B, it is getting more and more difficult for them. Probably that is the reason why it has not happened. The other way to look at it is that it is important to this 120A is very important, more particularly because of the type of offenses that are happening now. In most of the offenses, nobody knows who is behind it. So therefore, if it is so loose-ended, the problem is that you will only be catching the person who committed it, and the persons who are instrumental to it will all go scot-free. So it is very important that there is more focus on the Directorate of Prosecution to really inculcate or educate the police as to how they have to investigate a case involving conspiracy, what type of materials they'll have to collect at the time of investigation, and how this charge of conspiracy must be established by court. If this does not happen, I fear that going forward it will be very, very difficult, because the courts seem to be taking a very stringent approach when it comes to proving the charge of conspiracy. Thank you so much.
So not only dealing with the topic, but also a message at the end. That is, throughout, I'd say, not just in the end. As we near the century, hitting century in our sessions, we are improving day by day, sir. The methodology, the way in which the classes are going, it is it's becoming awesome in the sense like it's more and more useful to all the participants. Over to you, Ramkumar, sir, for your comments.
We had the touch of an expert. This is how a lecture should be delivered, with reference to fact situations decided by courts, especially Supreme Court. In fact, that is one of the methodology which is being followed by me.
Yes,
I also give problems for the law to be applied.
Yes.
Now, this is a real open heart surgery on criminal conspiracy with a guarantee for prolonged life expectancy. And you are wary that whether it will be, that guarantee will last long. That's a real doubt. Anyway, regarding the two convictions, one for 120B and for the other offense, we need not worry, because every court is awarding concurrent sentence only. No court is awarding consecutive sentence. Even if there are two convictions.
Yeah.
Thank you. Excellent.
Thank you, sir. Thank you.
Thank you very much, Justice Ramkumar, sir. Justice Ramakrishnan, sir.
It's an excellent lecture, Mr. Anand Venkatesh.
Thank you, sir.
You have really, in fact, though these aspects were conducted by now Justice Nagamuthu and Prakash also, you are very careful in not overlapping on those areas and having independent way of projecting as to how and what are all the lackings that comes in the hands of the prosecution in not using 120B really where such offenses are made out, and also the consequences of not using that provision on the society, considering the present rate of nature of offenses that is being committed. So the big shots who are behind it will be left free, and only those persons who have committed the offense are likely to be trapped.
Yes.
Thank you very much. Very nice lecture.
Thank you, sir. Thank you.
Sir, maybe we dealt with the different issues in that problem or issue-based approach.
Yes.
There isn't any question put up by anybody, but I believe if Ramesh, Advocate Ramesh, senior advocate, is here, kindly unmute and address. He was there throughout the
I see.
session. Sir, are you there?
Apart from the Almighty, there are other unseen persons.
I don't think so. Sir, 1 second, two more messages. Let me just take out.
Yeah.
Ramkumar sir, there is much concern about your health after that marathon session in the morning. Everybody is concerned about your health, and please take care because we want you, because you are the backbone of our program. Maybe a selfish request, but still.
No. All of us, sir. All of us. It's not confined to Shyampadman.
I am all right.
Take care of your health.
Tomorrow morning I'll be all right.
Okay.
Absolutely, sir. You have to. And now that there is no further clarification, sir, a request is coming whether you can share the notes so that I can put it in the
Surely, sir. Surely.
You can just share the notes.
This is all borrowed. This is all borrowed intelligence. It does not belong to me. It belongs to
the way it has been articulated will be very easy for others to follow.
Surely, sir. Surely.
So, sir, over to Prem.
Well, so it was indeed what I would call a dazzling elucidation of the whole subject, which was well explicated. And thanks a lot, sir. And with regard to the first case, sir, that Malkahi case, I think it is what is written was 1867. It was shown like, actually that's 1868.
1868 is it? Okay.
Let me ask you just one thing. As far as conspiracy is concerned, see the proviso to that section 120A, that proviso lays down that no agreement except an agreement to commit an offense shall amount to conspiracy unless there is some act besides the agreement which is done by one or more parties to such agreement in pursuance thereof.
Correct.
And subsequently, nowadays we see almost in especially in the cases which are charged by the CBI, in each and every case there will be 120B.
Yes.
Isn't it necessary for a charge to contain the exact particulars regarding at what time, at which day, at which particular place, in which particular manner did the criminal conspiracy take place? Why I'm asking is because sections 211 and 212 abundantly the legislature cautions the charge shall contain the particulars and kindly be scheduled. I mean form 32. It's written particular time, date, everything. So even though conspiracy, if we could infer, but still isn't it mandatory because it should contain that particular place?
In fact, I had prepared a note on that since it is available. Charat, can you put that also?
Yes, sir. One second.
I think I had prepared too much for this. So anyway,
no, sir, there is nothing like too much. We are our what do you call desire to have more is something.
In fact, what I did was I had split it up into 34, 120B, and 149. But I have said what a charge should contain, and a bird's eye view about what it is. So if you can just see it, this is the one. This is the one which I prepared. Just look at it. So this is a bird's eye view of section 34, 120B and 149. So what I have done is I have split it up this way. What I have done is that what is 34, what is 120B and 149. And then the ingredients I have put it at the top. Substantive offense, then common intention, common object, premeditation and concert in mind, joint and constructive liability, requirement of overt act. This is what I have done. And what I have done is 34 I have said it is a rule of evidence. 120B I have said yes, it is a substantive offense. And 149 I have said does not create a new offense is what I have said. Then common intention I have said 34 yes, 120B and 149 they are different. They are not, even though you used yes. So I have consciously said that it is not. So then common object, obviously I had put it to both 120B and 149. See, now premeditation and concert, obviously it is there. It can, see, there is a small difference. That is why, see, the 34, it can be formed on the spot.
On the spot.
120B, it must be formed prior to the commission of the offense.
Yes.
And 149 again can be formed on the spot or at any stage, also. See, that is why just because you have a charge under 34 or a charge under 149 does not mean you will also be able to satisfy the charge under 120B.
Exactly.
It's very important to understand that. So the joint and constructive, yes. Then the requirement of overt act, yes for 1 and 3 and not for 120B. Now, when you go back on the charge to be framed, just go back on. Yes, 120B. Charge framed under section 34, 120B and 149. The first thing is about 34, which I have said. 34. Just come down. Where I have suggested that even in a case where a charge is framed under 34 IPC along with the substantive offence, an alternate charge under 120B can be framed, since premeditation or a prearranged plan is one of the main ingredients of both 34 and 120B.
120B.
It's all courts can follow it as a matter of procedure itself. They can always have an alternative charge. So that somebody does, in the course of evidence, when that is established, you can always say that there is a charge already. So therefore, that alternate charge is possible. Then 120B, section 211.1 read with section 218 CRPC makes it clear that there can never be an omnibus charge framed as against all accused persons.
Exactly.
I thought I read the mind of Mr. Menon today. So yeah, an offence of criminal conspiracy is a substantive offence by itself. The provision itself provides for a punishment. Therefore, wherever there is meeting of minds to do an illegal act, whether such an act ultimately came to be committed or not by itself is not an offence and requires a separate charge to be framed. Criminal conspiracy is a species and abatement is a genus. Where the charge is framed for the substantive offence with the aid of 109 IPC for abatement, an alternate charge can also be framed under 120B, then 109 and 120B. The one thing which I have not stated is, should I give the particulars exactly as to where it came? According to me, to begin with, as I told you, it's a reverse engineering process. Basically, the prosecution has to place certain materials and take it back from the commission of the offence till that original conspiracy had taken place, and it has to provide with those particulars before the court. Insofar as framing of charge is concerned, doing it exactly in the way it is required is something which may not be possible in conspiracy, because in most of the conspiracy, it is an inference which is acting. And therefore,
sir, why I am asking is that because every court would say, see, conspiracy is always hashed in secrecy.
Correct, sir.
So it may not be possible.
Yes.
But at the same time, you have to keep in mind that if an offence is committed, the manner in which it's committed, because it cannot be presumed by the court from a
should be stated. Should be stated. What I'm saying is the exact details. Correct. When, at what time, what not be possible in many cases at all. In a case of conspiracy, it may not be. But as you rightly say, there has to be materials to prima facie come to a conclusion that there was a conspiracy. That prima facie material is very much required when you frame a charge of conspiracy.
My phone is shutting down. Battery is empty.
Okay.
Sorry.
Okay. No problem. Yes.
Phone is shutting down.
Yeah, no problem, sir.
So you have made a very elaborate note, and it covers every nook and corner of this particular subject.
Yes.
It's wonderful. Absolutely brilliant.
Thank you.
Sir, this is what we have always been aspiring for, and we are trying to implement in this platform. Legal empowerment through interaction.
Yes.
Lecture series is the second part, sir. The first part is what we give importance. And today we did experience something entirely different. It was a great experience. It was wonderful, sir. Thank you very much for being part of this platform. We expect you to be here throughout. I mean, the same way we were compelling Justice Ramkumar, sir, and Ramakrishnan, sir, and others to be part of this platform. It's always for interaction, sir. Because that opens up new vistas, new avenues of thoughts, and maybe, like you said, we may relearn, unlearn, and also find new avenues.
Correct. Thank you so much, and I'm very happy to get a good certificate from this forum, for which I have always had a very high esteem in terms of standard. So thank you so much. I did my best. I also learned a lot in this process.
Sir, actually, I would say that yours was one of the best classes we had.
Thank you.
Absolutely, it was fantastic.
Because it was so critical and also analytical also. That is the way in which it has been put.
Yes. Thank you. Thank you so much to all. Thank you. Thank you for your time.
No, Venkatesh, I want to know whether you are a criminal lawyer or a civil lawyer.
I am basically a civil lawyer.
So most of the civil lawyers have become good criminal judges.
Yes,
Normally.
I always, yes. You are right. You are right.
Ramkumar sir used to say that throughout his practice, he never had even a 138 or a criminal brief. Then he became one among the best, judges on the criminal side, and one of the faculties most coveted and sought after faculties for criminal jurisprudence.
That's
he would never say as a criminal judge. He would always say, I am a civilized criminal.
No, what I find from, because the same thing is for my experience also. Because the civil judges always go on the question of probabilities.
Yes.
You are analyzing in the probability.
Yes.
And thereafter make it an offense.
Yes.
Which is make it beyond reasonable doubt. So thereby you are able to connect the weakness of the prosecution and close the case put forward by the accused. That way we are able to develop things.
Yes. Thank you, sir. Thank you for opportunity. Thank you for your time. Thank you.
So that brings us to the end of the 87th session of the Legal Empowerment Through Interaction lecture series. Tomorrow in the 88th session, we have the Principal Judge of Family Court, Nandit in Maharashtra, Ms. Swati A. Chauhan, dealing with a very, very pertinent issue, the issue of maintenance during COVID times. So till we meet again tomorrow, 3:30, stay safe, take care.